Ayan, 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 ayan. Nakamute ko na.
Good morning, everyone. Could I ask if everyone can move to a table of at least 3 or 5, that would be great. So this helps us with our breakout room. So if you could just bring yourselves in a little bit, that would be great. And we'll be commencing in about 5 minutes. Thank you so much.
Morning, everyone. Just a few more minutes. So good morning, everyone. Just to update you, just a few more minutes. We're just getting everyone settled. So the Honorable Justice Singh and the commissioners have arrived, and the chairperson, Melanie of LEB. So if you just a few more participants are still arriving, so just a few more minutes. Thank you. But feel free to grab any refreshments outside. Thanks. Good morning, everyone. So we will commence. We'll commence in 2 minutes, so if people can sort of settle in. And this is for real. We're really gonna kick off, even though people aren't settled in. But I think we should proceed. It's already 10 past 8:30. So how's everyone feeling? So welcome to ADB's new auditorium. It's actually very beautiful. This is my first experience here, so hopefully everything will go smoothly. But it's really, really nice. Just doing some small talk during COVID times, I guess one positive outcome was that many of the areas were recently refurbished and modernized. So I think it'll be really helpful for hybrid interactions like this. So we're really looking forward to see how this auditorium plays out. So it seems like we can commence. Excellent, excellent. So it's so great to welcome all of you to the Asian Development Bank in our brand new auditorium. This event has been in the works for many months. And I know that the Legal Education Board and then the ADB teams have been working very hard to bring you all here together today in person and also online. So we are so pleased to see all of you here. So I'm Christina Pak, Principal Counsel of the Asian Development Bank. I will be your MC for the opening ceremonies. So it's really an honor to have all of you, especially our honored guests, especially the Associate Supreme Court Justice Singh, Chairperson Anna Murray, Melanie Trinidad, and Commissioner Jojo, and Professor, I haven't seen Professor Rose Lisa, the governing chair of the IUCN Academy. So hopefully she'll arrive, but just new faces and familiar faces because we've been on this journey for a long time. So we will commence with prayer and anthem.
The cause of wisdom, the source of intelligence. We welcome you, O Lord, to this auspicious gathering of your beloved, who continuously give you thanks for every opportunity to learn something new and become fruitful to the works of your creation. We humbly come to you, not because we are worthy, but because we find ourselves in need of you, who is our strength and our hope. to continue despite the challenges we face in health, prosperity, and our solidarity with one another. We pray that today's gathering, made possible by the grace of advancements in technology and social media, becomes successful in its endeavors, so we can offer it back to you as our humble offering to honor you, glorify you, and love you through our deeper connection with everyone. May we find bliss in today's session and become more productive children and co-creators of the earth. This we ask and pray through Christ our Lord. Amen.
Thank you, everyone. It's always great to start with some positive prayer and some affirmations. So we will commence with the opening speakers. Please have a seat. Excellent. So our first speaker, I'm absolutely proud to introduce our General Counsel, Thomas Clark. Besides everything he does throughout the bank, he basically is the legal advisor for the institution as well as so many different stakeholders. He's been an absolute champion of our law and policy reform program, and in particular for our developing environmental law champions, TA. And he's basically been such a strong advocate, both internally and externally. And we are just delighted that he can join us. Some of you may recall that he was able to join us virtually last time, but it's just amazing that we can actually, be here in person together to continue our partnership with the LEB. So I'd like to introduce Thomas Clark, the General Counsel of the Asian Development Bank, to make his opening remarks. Thanks.
Thank you, Christina, for those very warm words of welcome. And let me say, magandang umaga to all of you. Good morning. I must say, I completely, from the bottom of my heart, second Christina's remarks about how good it is to be here with you in person today. The technology that has enabled virtual meetings to take place over the pandemic of the last few years, of course, was a grace. It did allow us to stay together, but seeing you all here in person reminds me that it's no substitute for meeting in person and having this kind of fellowship and in-person discussion that we're having today. So I really am deeply appreciative of your presence here, but also of all of the people who are joining online. I'd like to extend a very sincere and special welcome to the Honorable Maria Filomena Singh, Associate Justice of the Supreme Court of the Philippines, to Ms. Ana Marie Melanie Trinidad, Chairperson of the Philippine Legal Education Board, to LEB commissioners, Jojo Suryatai and Lorenzo Reyes and Selex Boga and Alexander Dumpa, and of course, Professor Rosaliz Osorio, chair of the governing board of the IUCN Academy of Environmental Law, and so many other distinguished speakers and members of the Academy, respected colleagues, guests, and friends. Thank you. You honor us here at ADB with your presence, whether here or online. It's a privilege, a real privilege, to welcome you to ADB headquarters for the second environmental law faculty training. And we've come so far, not only the fact that we're here in person now, but we've come so far from the first Philippines environmental law teachers training program just a little over a year ago in September of 2021. It's such a pleasure to convene this training in person and to meet so many of you, as well as allow for others to join virtually. Now, the new hybrid world has many benefits, including that the legal education sector, which I understand it was discussed at yesterday's consultation on the future of legal education in the Philippines, provides many opportunities to facilitate the kind of training that is so desperately needed. ADB is also grateful for the partnership with the Philippine Legal Education Board, as well as the support, the great support from the Philippine Supreme Court, the IUCN Academy of Environmental Law, the United Nations Environment Program, and all of you enable us to strengthen environment and climate change legal education in the Philippines and beyond. Now, even though it's only been a year, wow, what a year it has been since our last event. So much has happened in our world with mounting crises, from humanitarian to environment and climate change disasters. In truth, it really does feel like time is running out for people and for the planet. Now, at the recently held International Environmental Law Conference in Oslo, and many, Justice Singh and several others of you may have been there with me, you know, sirens were going off. Sirens were going off even louder because there was a palpable recognition among the experts there that our window of opportunity is rapidly closing in which to address the intensifying global environmental and climate crises. At the Oslo conference, environment and climate change experts around the world came together to discuss how to accelerate action. You know, if I heard it once, I think I heard it a dozen times there. The talk has been very good, but the issue is, how does the talk get reduced to action and put into play? And it was reaffirmed that strengthening environmental legal education is actually crucial to enabling the transformative change needed to move toward a more inclusive and sustainable path. So yes, we need more legislation. Yes, we need more treaties. Yes, we need a lot more actions that can be taken at the level of states and international actors. But a key element of that is enabling the kind of mindset that comes from education. And that's why your role is so critical. Furthermore, voices from Asia, represented by Commissioner Jojo and Professor Rosaliz Osorio and other environmental law champions there, showcase the efforts that are being made in our region, in the Asia Pacific, including the great work of the Philippines Legal Education Board in mainstreaming and modernizing environmental legal education. I was so proud to be there in Oslo, because looking around the room, you think, oh, Europe is way ahead and, maybe Asia Pacific is behind. It was demonstrated that that's not true, that a lot of the great things that are happening in this space are coming from our region, and including from right here in the Philippines. Now, ADB has a long history, one we're very proud of technical assistance supporting environmental legal education in Asia. And we're proud of the partnerships that we've been able to forge with environmental law academics and institutions all throughout our region. In fact, when I think about it, our first intervention goes back to 1995, when we worked with pioneers to integrate environmental law into the curricula of law schools in Asia and the Pacific. That was 1995. So today it's like, what? My math isn't good, but it's almost 30 years, I think. Almost 30 years later, and that program continues in the form of ADB's Developing Environmental Law Champions Program, which was launched in 2015 right here in ADB headquarters. And at that time, we noticed clearly that a significant challenge in meeting the increasing need for environmental and climate change experts was the lack of investment and capacity in legal education. Now, to address this issue, ADB gathered at the time 57 senior professors from 14 countries right here in Manila, including Professors Rose Liz Osorio and Gertie Mayoanda and our own Christina Pak, with the goal of improving the teaching capacity of environmental law in our region. Now, 7 years later, that's easier math, right? 2015 to 2022. 7 years later, these environmental law champions have led their own in-country training programs, helped to improve environmental law curricula in their institutions and countries. And most importantly, they've helped make environmental law a core subject. A core subject, not something that's like boutique, not something just for people who are, kind of like climate gurus. No, a core subject that every legal professional needs to know about because it's existential. It is core to a legal education. And they've contributed to country and regional knowledge sharing events. I'm also so proud that the Environmental Law Champions Network, which we have worked a lot on, has come to include over 500 academics from 320 institutions across 14 countries, including the Philippines. I mean, it's a significant growth, and it gives me some hope that this is a trend that will continue and grow all of the colleagues that we need to come into this climate space to help make a difference. But I think when I hear about those numbers, it makes me have hope. But although we've achieved a lot together, there must be more investment, much more investment in environmental and climate change legal education. The demand for environmental and climate change law expertise has been rapidly growing, driven by new policies and laws, as well as new specialist environmental law courts. These are all great developments, but there are still insufficient numbers of suitably qualified environmental and climate law experts, especially in our region. So what's the message here? We've worked hard. The trend lines are positive, but there is still so much more, much more to do ahead of us. ADB considers strengthening the capacity of environmental law educators an urgent priority, and the reason is simple. We all know that education is the foundation, and developing a green mindset really starts in the classroom with teachers who inspire. We were just having some discussions before the start about how, brilliant scholars aren't necessarily great teachers. Now we need both, but having teachers who inspire, who not only know the subject, but are passionate about the subject, who are passionate about why it's an existential issue for all of us, that's what we need to be inculcating. Now, importantly, environment law educators are responsible for creating the next pipeline of law practitioners, civil servants, policymakers, legislators, and judges who will influence sustainability outcomes. At the same time, environmental law educators serve as crucial resources, absolutely vital, and trainers to the government, judiciary, business, CSOs, and indigenous communities. If the legal education system lacks the capacity, lacks the resources, lacks all of what's needed, sustainable development outcomes can, and they most certainly will, be compromised. ADB believes that our environmental law professors are a crucial piece of the puzzle as we move toward transformative change. And I am very happy to report that ADB will continue to support our Developing Environmental Law Champions program with the launch of a new technical assistance next year. We are not here just for today or tomorrow. ADB is here for the long run with you to support these programs. We have here with us today absolute champions of environmental law, and I am immensely grateful for what all of you, everyone in this room, everyone listening, all the supporters, all the people who are involved with this program have done, and what all of you continue to do. Thank you so very much. I wish you from the bottom of my heart a very successful program over the next 2 days. I look forward to hearing about the outcomes because so much of the future is in your hands. Thank you very much.
That was an absolute amazing delivery, inspiring speech, Tom. And Tom is now one of our strongest environmental law champions. I really felt this energy. So thank you for that inspiring speech, Tom. Really appreciate it. Next, I have the absolute privilege to introduce the chairperson of the LEB, Anna Marie Melanie Trinidad, who under her leadership, we started our partnership last year. And Ms. Chairperson Trinidad, upon her chairmanship, basically supported our partnership. So we're really grateful for starting something just amazing with the LEB. And we welcome you to our program and to ADB. So the floor is yours. Thanks.
Thank you, Christina. Honorable Maria Filomena D. Singh, Associate Justice of the Supreme Court. Ms. Christina Pak, Principal Counsel and Team Leader for the Law and Policy Program. My speech. Sorry. You just stay there. Mr. Thomas Clark, General Counsel. Mr. Jonathan Lidgeblad, Senior Lecturer of the Australian National University. Could you just get my phone there? My speech is also there. Sorry about that. I really apologize. I was just going to say that it would be hard to follow the energetic delivery of Mr. Clark. Now it'll be hard to not deliver. Okay. Professor Rose Liza Osorio, Governing Board of the IUCN Academy of Environmental Law. Professor Amanda Kennedy, Senior Fellow of the Higher Education Academy of the United Kingdom. Griselda Gerthy Mayo Anda of the Palawan State University. Mr. Matthew Baird, Regional Environmental and Climate Law and Governance Expert. Attorney Joyce Melkar Tan, Lawyer for Asia Climate and Energy of Client Earth. And Georgina Lloyd, Regional Coordinator for the Environmental Law and Governance of UN Environment Program. I'd also like to greet Commissioners of the LEB, starting with Commissioner Lorenzo R. Reyes, Honorable Commissioner Josefe Soreda T, Honorable Salex Alibogha, and Honorable Alex Tumpa, professors, ladies and gentlemen, good morning to each and every one of you. Each of us here today is either a lawyer, a legal educator, an expert in his or her own field, or all of them at once. We have gathered together because we are fully aware of the unfortunate state of the environment in the world and in our country, and we all want to do something. As learned individuals, there is a mutual recognition of the immediate necessity to address the environmental degradation caused by abuse by man and even by machine. As stalwarts of justice, we are empowered by our profession to be active champions of this mutual cause. As Filipinos, we have the duty to actively participate in the environmental protection for ourselves, for our families, and for our nation. According to the U.S. National Oceanic and Atmospheric Administration, the 9 years from 2013 to 2021 have been the warmest years in the world. This rise in the global temperature has severely affected agriculture, infrastructure, and of course, the food supply, to name just a few. Now, whenever there is an environmental imbalance, third world countries have the most difficulty recovering. But as expected, Filipinos have learned to be resilient, adaptive, and accepting of this fate, which should not be the case. We cannot celebrate resilience if the misfortune had been almost intentionally thrown upon us. We shouldn't be adaptive to institutional abuse and the incompetence of those charged with the care and protection of our environment. And we cannot call ourselves accepting if it is about a tragedy that we are all co-creators of. As we all know, see, and feel, we are on the verge, if not in the middle, of an environmental disaster. Disaster here is not just limited to the blows from typhoons, volcanic eruptions, and earthquakes, but also the failure in prevention and response. The Philippines, an archipelagic country in the Pacific, is one of the most vulnerable positions against environmental disasters. The problems are both domestic and international. Locally, we have environmental laws that are not being implemented properly. Globally, of course, the environmental abuse committed by the most powerful of nations will inevitably impact the most powerless. The irony is that we are not truly empty-handed. We actually possess a lot of tools. We have policies, but they need implementation. We have laws, but they need adjudication. And we have people, and they need environmental rights and duties education. Undeniably, there is a sufficient demand for environmental law practitioners. A huge fraction of the Philippine landmass is either a forest, a domain of an indigenous people, a wetland, or a farmland. For the purpose of protecting our forests, therefore, our farms, our ancestral domains, and our natural resources as well, environmental law practice is ripe for litigation. Indeed, we must find ways to self-protect, for in the words of the former US President Franklin D. Roosevelt, and open quote, a nation that destroys its soil, destroys itself. Forests are the lungs of our land, purifying the air and giving strength to our people, end of quote. It was in 2021, as said earlier, with the Legal Education Board, the Asian Development Bank, the United Nations Environment Program, and the IUCN Academy of Environmental Law first initiated this training program to capacitate legal educators in the country on the way of teaching environmental and climate change law. We felt the need to develop a deeper engagement in legal education and believed that the new skills and knowledge to be learned thereby will enlighten our legal educators and equip them with the tools on environmental law practice, which will cascade as they teach environmental law. To the law professors who have decided to step up to this challenge, we thank you for your interest in environmental and climate justice and your commitment to effectively inculcate in the minds of the students and any Earth inhabitant for that matter, the urgent need for the institutional protection of our environment. Because lest we forget, All of us here, whether lawyers or educators or experts, we are just guests on this earth. Let us be courteous visitors and teach everyone else to be the same. Thank you for listening, and good morning once again to each and every one of you.
Thank you, Chairperson Melanie, and thanks for shedding special light on in the Philippines, and again for your inspiring words as well. Our next speaker, Professor Rose Lisa Osorio, who is the chair of the governing board of the IUCN Academy of Environmental Law. Unfortunately, she's a bit delayed. She'll arrive, join us later. But perhaps I can take the opportunity to really, rave about her because she's well known in the Philippines. I mean, she's a professor. She's also an amazing lawyer who wins cases, and she is, one of our environmental champions who is now the chair of the governing board of the IUCN Academy of Environmental Law. I say this again because it's an international network of law schools around the world. So we were extremely proud of our professor, Rose Lisa, for basically taking the helm. And she was instrumental in basically linking us up with the LEB and bringing all of you together. So we will have the opportunity to see her later, but I just wanted to just speak on her behalf and just say how wonderful it is to get her support and the support of the IUCN Academy of Environmental Law. Next, we will move to our keynote address by the Honorable Maria Philomena Singh, Associate Justice of the Supreme Court. And it is so amazing to have you here, Justice Singh, and to have the support of the Supreme Court. And we were so lucky to actually, meet you finally, at least for me, because I met you at the Philippine Supreme Court meeting last Friday. And then I know you joined our team in Oslo. And Justice Singh has recently been elevated to the Supreme Court in 2021. So it's so timely that she's actually joined our network, but really she's been working with the LEB in the past as well, even just joining the bench at the Supreme Court. She's so active already in so many committees, like the compilation of the rules of pleading, practice, and procedure. She's also the co-chairperson of the Committee on Gender Responsiveness in the Judiciary. And she's also the vice chairperson of the subcommittee for the revision of the Code of Professional Responsibility and much more. But she's been a judge since 2002. So it's an extreme honor, Justice Singh, to have you here, and I will give you the floor. Thank you.
Thank you. Please sit down. ADB General Counsel, Mr. Thomas Clark, Ms. Christina Pack, Principal Counsel and Team Leader, LEB Chairperson Attorney Ana Marie Melanie Trinidad, LEB Commissioners Dean Jojo Sorerati, my good friend, and Commissioner Lawrence Reyes. Professor Rose Lisa Osorio, the chair of the governing board of the IUCN Academy of Environmental Law. We understand that her flight was affected by the recent incident in the airport in Cebu. And glad to see again Matthew Baird, who was with us in Oslo. Esteemed professors and experts in environmental law, ladies and gentlemen, a pleasant good morning to everyone. We are gathered today for this conference to answer the question, what is the future of environmental law? I understand and testify to the impetus that education can provide. I am a firm believer that action must always be preceded by understanding for it to be truly creative and productive. Hence, education through which we acquire the necessary knowledge and skills as well as values is a primary tool in the fight for environmental protection and conservation. To this end, the revised model law curriculum of the Legal Education Board is truly a big step forward for its inclusion of environmental law as a mandatory subject in the curriculum. I was fortunate to have worked as the expert consultant of the LEB in the drafting of the revised model law curriculum. We congratulate the Legal Education Board. Capacity building for our professors through trainings like this seminar is another key driver. I have gone over the program for today and tomorrow, and I know that our participating faculty stand to gain tremendously from the sessions on environmental law education post-pandemic, the development of e-learning courses and hybrid teaching modules, the propagation of student-centric training and learning, and the use of varied teaching methodologies for maximum student engagement. Like any other teacher, I believe that the classroom is a most fertile ground for action, as mentioned by Mr. Clark. Starting with our students is definitely a must in our efforts to raise consciousness and hopefully to spur action. But after education, what is next? When our students leave our classrooms, what happens to our objectives? I stand in front of all of you, professors of environmental law, to speak about a subject I claim no expertise in. I heard this from Mr. Clark when we were in Oslo. Although I am a professor of law myself, I cannot claim to be a specialist in environmental law, at least not academically. Unlike all of you, I did not take up any special studies on the subject, nor have I conducted focused research on the matter, save what I needed to do on my own by reason of my adjudicative work. I have not even taught the subject. Neither have I previously joined any group or network sponsoring or implementing projects specifically dedicated to the protection of the environment. I belong to the majority of the 110 million Filipinos who do not carry the distinction of being an environmentalist, open and close quotation marks. And yet, I claim an equal concern for our environment. I am animated by a like passion to protect and preserve the place we all commonly call our home. And I am actuated by a grave sense of urgency, which I believe I share with all of you, to do something and to do it quick. I propose that this is the area where we need to focus our attention, efforts, and resources. When our students leave our classrooms, they go out into the world armed with the necessary information and learning that will direct their life's course. But the greater population do not pass through our classrooms. The greater population remain unschooled in environmental law, as in truth, the greater population will find it hard to understand the principles and theories, the philosophies and concepts that we spout. To the greater majority, these are close to incomprehensible. And this is why the greater majority do not feel the same sense of urgency that we feel. This is why, despite all the data and the statistics, the informed projections, the science-backed calculations, the greater majority go on with their way of life, unperturbed, unconcerned, trusting that life as they know it will continue forever and ever. Greed is the big bad wolf we always cry out against, the source of all that ails the environment. But for me, the real enemy is ignorance. We must therefore go beyond our classrooms to push our agenda. The Supreme Court, led by the Chief Justice, the Honorable Alexander G. Hesmundo, launched the Strategic Plan for Judicial Innovations 2022 to 2027, or the SPJI, on October 14, 2022. Christina and Bryony were with us on that day. The SPJI is the blueprint for action, the roadmap that the Supreme Court will follow in the next 5 years to make its services more efficient, innovative, and accessible. For our part then, your Supreme Court, we propose to pursue the following activities to promote environmental awareness, conservation, and protection. Because like Mr. Clark, we feel that we must take action. First, we will launch our green buses. I talked about this in Oslo. Some of you may be familiar with our Justice on Wheels program, where we use buses to go to places or stations, court stations with congested dockets. We will now transform our e-JAW buses into green buses by making them our model or template of what our future fully electronic and paperless courts will look like. These green buses will be deployed in congested court stations to aid in docket reduction, with a special focus on areas with a high volume or backlogged environmental cases. Second, we are going to initiate an inventory of all pending environmental cases in all our courts nationwide, both in the trial courts and in the appellate courts, with the objective of analyzing the trends, like what are the most commonly filed cases, relating them to the locality and maybe even the season or the time of year, or what philosophies are followed in judicial decisions handed down in these environmental cases. This will inform our future steps as a court, like what areas in environmental law we should conduct further training on for our judges and personnel. This inventory will also apprise us of the length of time cases have remained in the dockets of our courts and the reasons for any delay, which will in turn propel us to initiate any needed changes in our rules of procedure. Third, we will make our justice zones green zones. The Supreme Court, together with the Department of Justice and the Department of Interior and Local Government, constitute what is known as the Justice Sector Coordinating Council, or the JSCC. Through the JSCC, the sector approach to the delivery of justice is the chosen mode of action. We veer away from the traditional institution-based performance of functions. The JSCC sector approach adopts a coordinated modality for delivering sector services. This has resulted in greater efficiency and more economical resource management. The justice zones are the showcase for the sector approach of the JSCC. Our justice zones are hosted by local government units where there are sector-wide programs and activities that are operational, with the result that the overall goal of every justice zone is achieved, and that is responsive and real-time justice. At present, we have 9 established justice zones: Quezon City, Cebu City, Davao City, Bacolod City, Naga City, Calamba City in Laguna, and Balanga in Bataan, and Baguio City. Up next, we will be establishing our first ever trafficking-free justice zone, and that will be in Zamboanga City. We will propose to launch next our first ever green justice zone, and we will talk to you about the perfect locality for this. Fourth, also through the JSCC, we will propose to partner with all our barangays nationwide through the DILG for a massive information awareness campaign on the basics of environmental awareness, conservation, and protection, which will encapsulate the fundamental tenets you are all very conversant in, but broken down into easily understandable non-technical packets, practically applied to the different facets of the daily lives of the 110 million Filipinos. We will call these packets our Green Book. Fifth, we will continue to train our judges and lawyers on the rudiments of environmental law, and we'll also plan for sector training of justice sector actors, not just judges, but prosecutors, public defenders, law enforcers, under the JSCC for our Green Justice Zone, for more efficient and effective handling of environmental issues in the locality. Sixth, we will pave the way for greater access to environmental justice for those who need free, quality legal aid services through our revised law student practice rule under Rule 138A, which the LEB is supervising. These are just some of the plans and activities that your Supreme Court, through the SPJI, will undertake as our part, as your co-stewards in the shared advocacy to save and preserve the only planet we have. The sheer immensity of the threat to humanity should necessarily trigger the survival instinct in all of us. But this will only happen if we understand the nature and gravity of the threat. To stress, This means we must go beyond our classrooms and directly to the greater majority who remain unaware. But when we do, along with the information to raise awareness of the problems we face, we must also bring hope. But when otherwise, there is no pedal to push the change. And this is why I call the Supreme Court's strategic plan for judicial innovations as our special bundle of hope. I invite you all to invest your hope in the SPJI, support it, propagate it. We endeavor not to disappoint you. Thank you, and I wish everyone a productive session.
Thank you, Justice Singh, for your insightful words, words of inspiration. And just a reminder that we all have a special obligation with, to use our knowledge to really promote environmental justice. And it was wonderful that you shared some of the, Supreme Court's green initiatives, which we're looking forward to supporting. So thank you for that. And actually, I should have, Professor Rosemary Rosario, she is so quick. Of course she had a plan, even though her flight was delayed. She, quickly put together remarks that we can share with you. So I'd like to take the opportunity to share her remarks before we break, and then we will have the group photo. Thanks.
Distinguished guests, colleagues, and participants, good morning. On behalf of the IUCN Academy of Environmental Law Governing Board, it is my extreme honor to welcome you all to the second Environmental Law faculty training in the Philippines. The IUCN Academy of Environmental Law is an IUCN-recognized entity with a strong network of over 200 member institutions that seek to promote the teaching and research of environmental law. The members of the Academy engage in environmental law training and collaborative work across different member institutions. Each year, we hold a colloquium where all professors affiliated with these member institutions are invited to participate to present their latest research, teaching methodologies, tangible products of collaborative work among legal scholars across continents, and innovative thinking and applications of environmental law. One of the Academy's goals is building environmental legal education as a vital contributor to the environmental rule of law and to robust environmental governance as necessary ingredients for sustainable development. Thus, in close collaboration with the Philippine Legal Education Board and the Asian Development Bank, this environmental law faculty training aims to strengthen capacities of environmental law professors and seeks the development of a model environmental law syllabus. As the world continues to grapple with an environmental trilemma of biodiversity loss, climate change, and pollution, we need to find a better pathway for humanity. We need to find solutions and be part of the solutions. Most of all, it is incumbent upon us to cultivate environmental stewardship because, according to UNEP's Executive Director, Inger Andersen, by cultivating environmental stewardship, we can flip the switch to sustainability and save our planet. In 2020, when we were at the height of the pandemic lockdowns and bracing ourselves for another semester of teaching, we were probably all wondering how we will survive as teachers in the time of the pandemic. But this did not stop us. We managed to pull through by innovating, adjusting, and adapting. Although the challenge continues, we have continued to cultivate environmental stewardship in our students. But we can be better because the challenges are mounting. We are now in what the UN calls as a decade of action, so we can achieve our targets of keeping our planet healthy by 2030. As environmental law teachers, we not only teach what environmental law is, but we teach how to nurture the environment. Our business as teachers is nature, and our sole responsibility as environmental law professors is to plant the seeds of environmental stewardship. Sustainability is also our shared goal in environmental law. With these exceptional times, we need concrete solutions in order to achieve sustainability. This global crisis have showed us the crucial contribution of environmental law in helping our planet heal. In closing, we must not only acknowledge the vital role of environmental law, but rather we must also recognize its transformative power in affecting important environmental and social outcomes. Thus, this necessitates changing not only our perspectives, but also of those around us, our students. We also must challenge the status quo and stretch the limits of environmental law. So for the next 2 days, let me welcome you all to participate, open your minds, and learn with us, because we are all lifelong learners, and we must also be able to teach environmental law effectively to our future cohort of environmental law students in the country. Thank you once again. Welcome.
It's always great to hear from Professor Rose Lisa in whatever form. And, she's so amazing that she managed to put together a video message. So I'm so happy that we heard her. So now we will close the opening ceremony and then move to a group photo by our expert photographer, Angelo. And Angelo tells us that we should go right outside because the weather's nice. So we will just proceed there. Thank you. And for the online participants, can take the opportunity for a quick break. Thank you.
So, good morning, everyone. My name is Matthew Baird, and I'm the team leader for the Environmental Law Champions Program as a consultant with the Asian Development Bank. We'll just wait a few minutes while everyone comes in before we move on to the next presentation by Professor Amanda Kennedy from Queensland University of Technology. So just a few more minutes while everyone comes back into the room after the photo. And then after Professor Kennedy's talk, we will then have a short, we'll have the introduction to the program and then a short break for coffee and tea at about 10:15. So thank you. Just a few more minutes. Thank you very much. And thank you very much to all our online participants. We really appreciate, we know you're there in the great internet and Ethernet. And I can see you all now, so hello, waving to you all. And please, as I say, if you've got any questions or comments, please in the chat box, because we're monitoring that chat box. And of course, blended learning sessions are always exciting. And so we always keep learning. So thank you all very much for joining us online, and we will look forward to your questions and comments soon. So just one moment, and I'll just check to ensure that we're ready to go. Thank you. So good morning again. Thank you. And Chair Trinidad, thank you very much for your kind words, opening words. I am pleased now to introduce our speaker who will give a presentation on environmental law education in the post-pandemic world. Of course, we always hope we're in the post-pandemic world, but I'm not quite sure we've reached that stage yet. But Amanda Kennedy is a professor from Queensland University of Technology, and she joined the Queensland University of Technology as a professor of law in 2019. She's taught across undergraduate and postgraduate programs concerning natural resource governance, and more recently has been teaching animal law. Amanda has received peer recognition for her teaching practice, including the LexisNexis Australasian Teachers Association Citation for Excellence and Innovation in the Teaching of Law, and the IUCN Academy of Environmental Law Emerging Scholar Award, Education Award in 2016. She's currently the co-chair of the IUCN Academy of Environmental Law's Teaching and Capacity Building Committee. She's been a long-time supporter, trainer, organizer, and speaker with the environmental law champions from the Asian Development Bank. And it's with great pleasure that I welcome her to the podium. Thank you, Amanda.
Good morning, everyone. It is indeed a pleasure to be here and to, I guess, open the working component of our training session with a few brief remarks on teaching environmental law in a post-pandemic world, if indeed that is what we are finding ourselves in. I hope these comments will help frame our conversations for the next 2 days, and I look forward to our ongoing dialogue in the sessions that follow. Now, before I go on too much further, I just wanted to check with Angelo whether we have the slides available for this session. They're up. Fantastic, thank you. So why am I here to speak to you and to open this session? Well, next year, in fact, marks the 20th year in my teaching career. And I've spent a considerable part of my career in academia focused on the scholarship of teaching and learning. In other words, how we teach law, and specifically, and in more recent years, how we teach environmental law. And I've taught environmental law and several other subjects across a wide range of modalities. So face-to-face, but increasingly online and in blended formats. So I'm hoping to share some of that experience with you all over the next 2 days. So if we could move to the next slide, thank you. So first, let's set the scene with where things are at with respect to environmental law education broadly. Achieving sustainability, as we heard from some of our esteemed speakers this morning, requires a population that is equipped to deal with complex, interacting and ever-changing realities, as well as uncertain futures. And so this requires environmental law that is, and policy that is integrated, adaptive, and also forward-looking. We heard in some of the remarks this morning that it's not just about having elegant laws, but also implementation of those laws and enforcement as well. So it's a very complicated space. We've already heard again this morning that legal education plays a key role in shaping those sustainable futures and the role of environmental law. The work of judges, of lawyers, of policymakers can prohibit or legitimise particular environmental practices. And legal education, therefore, is highly influential due to its part in shaping those governance actors. Now, all of you will be very well aware that environmental law has emerged since the 1970s as a widely embraced component of the undergraduate law curriculum in many countries. It's also a specific focus increasingly in postgraduate programs in law, and also emerging as very much a focus of research. Now, whether it has become a mainstream part of legal education or if it still remains in the margins is open to debate, and of course the answer varies from one jurisdiction to the next. But while environmental law may still be an elective in some countries, it's moving in others towards being a compulsory and core component of legal education. And indeed, that is the case here in the Philippines, which is commendable. Despite its growth in the curriculum, there is widespread recognition among environmental law scholars that teaching environmental law involves a number of distinct challenges. Environmental law is broad. It is hard to delineate clear boundaries for the subject. The law changes rapidly, forced by not only advances in scientific knowledge, but also technological processes and political concerns. And in many nations, environmental law presents as predominantly a substantive subject that is really focused on statute. So that creates its own pedagogical challenges. But environmental lawyers, we know, also have to deal with the realities of policy, of planning instruments, and other forms of soft law. The emergence of environmental law principles such as sustainable development and the precautionary principle create a tension between legal formalism and new approaches to legal reasoning. And alongside these challenges, environmental law as a subject is characterised by great factual complexity, bringing into play interdisciplinarity and the need to consider the relationships between law and science, or law and economics, and the law and other socio-cultural concerns. So when it comes to environmental law educators, ascertaining the purpose, the scope, and the content of the subject of environmental law can prove quite challenging, and in some cases overwhelming enough to be a disincentive to go in and teach in that subject area. So we have that as very much a subject matter tension for the area of environmental law. If we could move to the next slide, please. Now, overlaid on these discipline perspectives, at least in recent years, of course, has been our experiences with COVID-19 and what this has meant for how we teach environmental law, both now and beyond the pandemic. Now, for some time, of course, prior to the pandemic, there has been a growing uptake of online teaching in tertiary education. Law has been no exception to this, but it has tended to lag behind other disciplines. Now, while there have been a variety of reasons for this, it has been argued that legal pedagogy has been largely driven by a preference for Socratic and didactic methods. And that's something that we're going to explore a little over the coming days. Nonetheless, And particularly in the last 10 years or so, there has been increasing evidence of e-learning adoption and innovation in law, ranging from blended or hybrid approaches which combine online and face-to-face formats to wholly online subjects, as well as entire degree programs. Now, for law schools that were not already embracing some form of e-learning, the COVID-19 pandemic in early 2020 forced an abrupt transition to online learning, not only here in the Philippines, of course, but all throughout the world. And so in order to ensure continuity of study for students during this unprecedented time, we had to pivot quickly to online delivery. As a result, online delivery quickly became the norm in most law schools, though somewhat predictably, the necessary haste in which that transition took place meant that online teaching was implemented in a way that resulted in very mixed reviews from law students, not only as to the quality and effectiveness of teaching, but also mixed reviews from faculty, from teachers, in terms of their experiences with managing the workload and dealing with student satisfaction. Now, while life is starting to return somewhat to normal, the fact that I'm standing here in front of you today, having travelled a couple of days ago from Australia, is testament to that. The reality is that we haven't yet transitioned back to our pre-pandemic life completely. And the fact that the majority of the participants in this workshop today are joining us online is testament to that. Angelo, if you could move to the next slide, that would be good. Now, just over 1 month ago, as classes were returning for our spring semester in Australia, where most, if not all universities have relaxed social distancing and lecture theatre occupancy requirements, the following story was featured in the national media following a post on Twitter. And I realise that might be a little small to read online, but to get the gist of it, there's a picture there of a lecture theatre that's empty that was tweeted by a professor from Sydney University. And it was the second time that this had happened to this particular lecturer, where he showed up to deliver his in-person lecture and nobody appeared. And so the post laments an empty lecture hall where not a single student has shown up, despite there being no restrictions. Angelo, if we could move to the next slide. And Twitter responded with further evidence of the same thing happening at other institutions, as well as the typical picture there in the top left-hand side of an empty Zoom room as well, with all of the cameras turned off. And I realise, of course, that there are times when that's necessary. The headline in the corner there reads that higher education needs to find the right balance between online and in-person teaching. Angela, if we could move to the next slide. So legal education, and by extension, environmental law education, is at a crossroads. An article in Forbes posited back very early in the pandemic that higher education is confronting an existential crisis and law schools are its poster child. Many people assumed that once the pandemic was over, or at least once we were able to resume in-person attendance, that online learning would go away. Yet the images that we've just seen show that students want to retain online learning, or at least they crave that flexibility to balance their study with family and work responsibilities that they experienced during the pandemic. But they aren't the only ones who are keen for online learning to remain. We have industry and professional bodies who are seeking law graduates with technological skills, are also behind the push to retain at least some aspect of online learning. And finally, universities who are under pressure to develop work-ready graduates for a digital world, and who also anticipate some cost savings to result from online teaching, also see the potential for online learning. So undoubtedly, one artifact of the pandemic is that online learning will undoubtedly expand and play a greater role in law curriculum design and delivery. As more institutions consider the possibility to retain online courses and programs, law professors need to think about moving beyond pandemic teaching and seriously consider how they can deliver quality legal education online. So if there's one big takeaway message from the COVID-19 pandemic, it's that teaching effectively online and in person is increasingly and vitally important if we want to achieve that goal of inspiring the next generation of environmental lawyers. Maybe you're thinking, well, once COVID recedes, once we can really start getting back in full population to on-campus learning, we won't really need to worry about being online. This has yet to happen. And in my view, and certainly what seems to be playing out so far, is probably unlikely. I think it's clear that the online train has left the station, and it's in all of our interests to be on it or risk being left behind. So having suffered the huge disruptions of that online learning pivot that we went through during COVID, educators now have a new perspective on the value of online options to keep students progressing throughout their studies. And we can also see the value of it in retaining students in their studies, whether it's during a pandemic, whether it's during a natural disaster, or some other significant life-changing challenges that all of our students go through at some point in time. The financial arguments for online teaching are very clear. The pedagogical arguments around online teaching are also clear, and we're going to unpack that over the next 2 days. But for me, and for many other educators, it's principally about the students and their experience. And if we are able to deliver effective online experiences, then why shouldn't we be considering online education? So if we care about our students, if we want them to learn and to succeed and to be inspired to continue as environmental law educators, then we need to embrace the opportunity to improve our online teaching, as well as our teaching in general, no matter what modality we teach in. So how do we help our faculty get better at online teaching? Next slide, please, Angelo. In order to do this, we need to briefly consider why some of our experiences with online teaching during the pandemic were less than satisfactory, which is one of the reasons why people tend to dismiss online teaching as effective. You've heard me mention already the concept of emergency online teaching. And I spoke yesterday with some of the members of the LEB about this idea as well. What we tended to do during the pandemic was very much in that pivot to online teaching, try to replicate what we were doing in the face-to-face classroom. So we used tools, particularly Zoom, to shift our classes online and to start doing synchronous live lectures online. Now, while that was commendable in the wake of everything else that was going on, it was implemented abruptly, involuntarily, in that not everyone agreed that that was the best method for them, and with variable access to appropriate technological infrastructure, staff training, and also student support. Students were online by force. The teaching was not designed for the medium. We persisted with long, lengthy, synchronous lectures, keeping students on Zoom for hours, where the Zoom fatigue inevitably set in. The pandemic also exposed a deep digital divide, and I know talking with my colleagues here in the Philippines, that was quite evident here, where we had significant issues with bandwidth and students not being able to stay connected. So that divide was very evident, where we had students who were able to continue accessing education and those who were left behind. Next slide, thanks, Angelo. So in a post-pandemic world where increased online learning seems inevitable, it's incumbent upon legal educators to think quite deliberately about what it means to teach online. And so this starts with the recognition that actually teaching online is different, and there is a distinct pedagogy for teaching online, and it is supported by educational theory. Now, in the early 1980s, Clark observed that electronic media technologies used in teaching are merely vehicles for delivering instruction, and that they are not responsible for influencing student learning outcomes any more than the truck that delivers our groceries causes changes in our nutrition. So in other words, if you're still ordering bad food, the truck that delivers it to you isn't going to change what you're putting into your mouth. So if you're using Zoom to deliver average content, Zoom isn't going to help you be a better teacher, right? So it's all about those underlying principles of good educational design, and that's what we're focused on in the TTT program. Now, while of course a lot has changed in terms of our delivery online and the tools we have available to us in the decades since this comment was made, that fundamental proposition is the same. The achievement of learning objectives is not influenced by the use of technology, but rather by the design of the instructional strategies that we use to reach our students. So the focus must be on pedagogy first, and then the tools that we use to implement that pedagogy, whether it is technology or more traditional face-to-face methods. And this is where things went wrong for many teachers during the pandemic, because we looked first to the technology and then gave a second thought after that to the what we were teaching. So we're going to dive deeply into this issue throughout the remainder of the TTT. But the fundamental thing that we need to recognise is that some types of teaching and learning may be more effectively delivered online, and some may be more effectively delivered in person. And we need to think about that from the base point, rather than being driven first by the technology. So when it comes to selecting teaching methods, there should be a clear pedagogical imperative for doing so. And this is where I think we're going to be heading post-pandemic. Just because we have access to online learning doesn't mean we necessarily should use it. And just because we can return to face-to-face learning doesn't mean that we should automatically do that either. We have to think about what is the most appropriate for the learning objectives and the settings that we're working in. For example, while there may be a temptation to use synchronous e-learning activities to replicate your in-person teaching, a requirement that staff and students be online at the exact same time actually contradicts the flexibility that is inherent in online learning. And I'm conscious that we have a number of people who are online right now with us in a synchronous setting, which kind of contradicts that, but we'll put that to the side. Now, where synchronous technologies are used to interact with large cohorts, class management can become cumbersome, and it's really important then for the lecturer to be in a position to be able to manage that cohort, much as we have here today, where I'm not responsible for managing the chat room at this point in time or any breakout groups, so that I can concentrate on delivering the content. In a survey of academics by the Legal Education Board of the Philippines, and I believe Rose Lisa was behind conducting that on their behalf, one of the biggest challenges identified for online teaching during the pandemic was poor internet connectivity, a fact that I am sure that many of you are aware of. And yet the most dominant method of teaching that was employed in the Philippines during that time was synchronous lecturing via Zoom. So if we can see that disconnect there between the environment that we were teaching in and the tools that we had available, you can start to see where we've kind of got things out of order in terms of how we should be approaching our pedagogy. So research into online education post-pandemic has really forced a great deal of effort into exploring what does effective online pedagogy look like. And so recent research proposes 5 pillars of online pedagogy. And Angelo, I'm not sure if you're here, but we can move to the next slide. And I just wanted to quickly mention these 5 pillars because we're going to be focused on those or aspects of those throughout the next 2 days. So, and I'm only going to briefly mention them now because we will have that opportunity to explore each of these pillars in much greater detail. So the first one is that we need to incorporate active learning. So when we moved into particularly synchronous Zoom teaching throughout the pandemic, it was very much delivered in a way that was that passive learning. So active learning is a broad concept and it includes interactions within the learning community, making connections with content. It recognises that learning is an active process, not just receiving information. So the learner has to do something in order to expand and grow and make sense of new knowledge. So this is where we start to look at using communication and collaborative tools and so on. The second pillar is building relationships and community, and the pandemic definitely demonstrated the importance of building relationships and communities in the absence of physical connection. And so research suggests that in the online setting, there are 3 ways that we can build those relationships. It's the students' connection with content, the students' connection with their peers, and the students' connection with their teachers. And so we call this presence. And those from the LEB who attended yesterday would recall me talking about that. We're also going to have a session where we focus on how do we cultivate that presence in the online learning environment to ensure that we are building those relationships and communities in the online realm. We also need to leverage learner agency. And what I mean by that is that we need to start helping students take responsibility for their own studies and their own learning, because that is how we actually improve metacognitive skills and also critical thinking. So this is where we give students some personal control in their learning, a variety of assessment approaches that they can select from, or different ways and methods of delivering content that students can select what is the most appropriate for them. The online learning environment allows that. And we also need to ensure that we are embracing mastery learning. And this pillar is somewhat connected to embracing learner agency. But what we're talking about when we say that we want students to embrace mastery learning, and I think Rose Lisa mentioned this concept in her address earlier, it allows students to progress at their own pace, developing an awareness of their own understanding and learning processes, but most importantly, it cultivates a sense of being a lifelong learner. Because if you go back to the comments I made at the opening, environmental law is a complex field. It's not static. It's not an area that students will undertake learning in and then not progress any further. They need to continue to grow and learn in that space. So we really want students to embrace that sense of mastery learning and to become independent, confident, lifelong learners. And finally, we need to personalise the learning process. And this is where students are given a little more control over the learning journey. They determine the pace of learning, the time and location of learning, and in a more advanced setting, might even choose the activities that are relevant to them. So by personalising the learning journey, again, we have a better opportunity to engage our students. So don't worry too much about those now. I just wanted to highlight them, but these are going to be focal points for us as we move through the next 2 days. Angelo, we're right for the last slide now. So the environmental law lecturer continues to confront significant challenges in terms of the scope of the discipline, what to include in their course, whether to stick to a purely doctrinal survey or whether to delve deeper into governance principles and operational and political, economic and social aspects of the law. The latter is challenging intellectually, and it's only becoming more so in the context of climate change and biodiversity loss. But it is important that we approach environmental law in ways that open up the minds of our students to different ways of thinking about how the law operates, and importantly, how it might be redesigned and what role they can play in that future. The pandemic forced legal educators to confront online learning for the first time, but there is nothing to suggest that online learning will go away. Quite the contrary. Students, industry, and universities themselves are all demanding that it be retained in some form. And in the case of environmental law, there are signs that online learning can actually provide a mechanism to enhance deep learning and the development of critical thinking skills, and to access a wide range of resources in a way that stimulates and engages and further inspires our students. So it's critical that we embrace online learning and use it to our advantage. Now, I'm not here to suggest that there is no place for in-person learning in the future. Put simply, as the slide here says, the pandemic dispelled the very widely held opinion that online learning could not suit law. Online education is likely to expand and play a far greater role in the law curriculum in terms of its design and delivery in the future. Figuring out which parts of the curriculum are suited to online delivery and which should be reserved for face-to-face delivery requires a deep examination of learning outcomes and pedagogy, and entails alignment of the subject matter, the desired learning outcomes, and the selected pedagogy with the mode of delivery. So I'm very much looking forward to discussing these issues with you over the next 2 days. Thank you.
Thank you, Amanda. Thank you, Professor Amanda. And can I just also mention that because we have online people, hello all online people, say hello everyone, 62 online people. Because we have the online people, we need very much to speak in the microphone so it goes through the Zoom, which is something that I always remember when people always say, you don't need, you can hear me without the microphone. I say, yes, but others may not be able to. So again, Professor Amanda, thank you so much for those words. There's obviously a lot more to say. There's a lot more to do. What I would like to do at the moment is ask if there are any questions that people have. If you're now, we can open it up.
If I may, I would actually, it was wonderful just now to see everybody waving online. Thank you all for turning your cameras on and waving. Can we see if there are questions online first? I'd like to throw to our online participants first to see if anyone has any comments or questions.
So anyone online who would like to ask a question? Now, we're very happy. I'm going to put Angelo and our wonderful tech team here on the spot. So if you want to speak and ask a question verbally rather than type it in, if you put if you can raise your hand, I think through the reaction box, you can see the hand raise signal. So if anyone online would like to ask a question or make a comment, please feel free to do so. I should also point out that because we have a wide variety of people doing environmental law and environmental law related activities, I think, Amanda, one of the things that I always take from your talks and your presentations is that it's not just about environmental law lecturing. It's about how we learn. The future of how we learn is going to be this blended approach online. So are there any shy people online who would like to ask a question?
Feel free to jump to the mic while we're waiting.
All
while
right.
we're waiting for
Anyone?
our online colleagues to...
Please, yes. And please, because we haven't had a chance to introduce ourselves, if you ask a question, could you please introduce yourself for everyone?
Yes.
Thank you.
Good morning to everyone. My name is Attorney Maralit. I represent Tomas Claudio Colleges, the first law school in Rizal province. So I'd like to just make a comment, not really a question. So I'd like to say that I'm excited about learning that about yung teaching methods that can be effective on online. It's good that there's an analysis of this, so good to know about that. So are there only just one method online, or are there many methods, or is online the method?
So we're looking at, that's a great question, actually.
Oh.
Thank you for your question. We'll get into the specifics of that in a little more depth over the next 2 days. But when we talk broadly about pedagogy, when we use the term pedagogy, we're talking about the methods of teaching, the methodology of teaching. So the science of learning, if you like. Within that, we have online methods, we have face-to-face methods. And then underneath that, there are a number of different methods. There could be student-centered methods, more didactic methods where it's about the lecturer teaching students. So our first, I guess, point where we're going to come to, I guess, a little later on today, Jyoti and I will be talking a little about theories of learning, so how people learn. That's the starting point with understanding the different approaches, and then we start getting into more detail. What are some of the specific methods and tools that you can implement to teach online? So it's definitely not just, and I think it's very easy to just think that online teaching is putting a Zoom class on. As you will hear, that's the easiest and simplest method of teaching online, and probably the least effective. So we'll talk more about that over the next 2 days. Thanks for your comment.
Question? Oh. Yeah, so we've had some discussion in the chat box that online learning is excellent, but not all topics and subjects are suitable for online. So I guess that's also is a question.
Absolutely. Yep.
That might be the conclusion, but how do you, is there an easy way to determine which subjects would be better for online or offline?
There's no easy way of determining that. I think that the point is that as long as you're having the conversation about it and trialing it, sometimes it is a little trial and error. as well in terms of testing whether certain topics are better suited to online or not. Certainly some activities are better suited to online delivery than face-to-face. The flip side of that, it's very easy to look at certain activities and think, it's just easier to do this face-to-face, but that's not to say it can't be done online. And Jyoti and I will be taking you through some clinical legal education examples, which we've delivered both face-to-face and also online, and how you might be able to use those tools to deliver that. But a very good consideration as to whether or not a certain topic area is better suited online or not. There's no easy answer, it's trial and error.
So we have also a hand up online. So if I can ask our tech people, can Jolie ma'am be able to give her?
Yes, sir.
Yes, we've got.
Yes, good morning. I'm Judge Shirley Requerme from Liceo de Cagayan University, Cagayan de Oro City. Well, a comment as well as in addition to what has been earlier discussed, I was struck with what the professor had shown about an empty university, in the face-to-face classes. Actually, we had a different experience here. I have 3 boys going to school, senior high school, and an elementary one. And they were saying that they were vastly disappointed that their school decided not to push through with a full face-to-face classes. So again, also with our classes in the law school, a lot of our students would also comment that though online classes are convenient, but it has a different impact when done face-to-face. So we really hope and we thank ADB and LEB for this initiative with the continuing conversations on, again, going back to the earlier comment on what works online and what not. So we thank you for this opportunity, and also we would like to hear more on what works so that we can also implement that and build this passion for our students to be environmental advocates. Thank you and good morning.
Thanks, great comment.
Thank you,
And definitely that's something that we'll be focused on over the next 2 days as we explore really what works online and what doesn't, because there's no easy answer. The key consideration is about being reflective and working through the content and really thinking quite rigorously about what is the most appropriate tool for not only the content you're teaching, but also the audience that you're teaching to.
And I think we have another online question from Teresa Camano. Ma'am? Judge, another judge.
Okay.
Thank you, Judge.
Good morning, everyone. Good morning, Professor. I am Judge Maria Teresa Camano, a law professor. And before asking my question, I just would like to share my experience also that when we got back to face-to-face, because in our university, we have a face-to-face schedule and then online. No? So when I got back to teaching face-to-face, I was kind of not liking it so much as I used to. It's like, I would rather prefer staying at home and do online teaching. So that's kind of weird because I really would want to interact with my students. Now, to my question, in law school, we do this, we have this Socratic method that we ask some sort of a question and answer portion with the students, recitation. Now, should law schools do away with the Socratic method when we do online classes? Because our dilemma, our problem rather, is that when we do receipts online, our students could easily search the answers to our questions. So somehow I'm thinking it's useless to conduct recitation when students could easily search and really do not read thoroughly the text or books given to them. And even in the case digest, they would just copy the digest online. So would it be advisable to simply do away with the Socratic method in teaching law schools? Thank you, Professor.
Judge, that's first of all, can I just say I can see why you have a preference for being online with that fantastic background that you have. If everyone can see, if all of your students see you as if you're on a tropical island all the time, then why not? But the question you ask is really at the heart of what we're going to be looking at over the next 2 days, and I'm so glad you've raised it. We just spent a day yesterday with the LEB unpacking this very issue, and that is the Socratic method the definitive method for teaching law? And there's a lot of discussion around this, and it's been throughout legal pedagogy scholarship for some time in terms of really questioning whether that methodology is actually the only way or the most effective way to teach law. Without preempting the content that we'll be going through over the next 2 days, what I can tell you is that there is simply no substantial empirical evidence that tells us that the Socratic method is the best way to teach law. We need to come back and look at theories of learning first to understand what the type of learning is that our students need to undertake. And part of that is considering the learning outcomes that we want our students to have. If the learning outcomes we want our students to have is to memorize sections of legislation or principles from cases and be able to deliver those rapid fire when they are put under pressure, then perhaps the Socratic method is appropriate. If we want our students to have a deep and comprehensive understanding of the application of principles of law and to be able to critically interrogate the operation of that law in practice and maybe to propose reform suggestions, then I would put to you that perhaps the Socratic method is not the most appropriate method. Again, I'm not suggesting that there is no place for the Socratic method, but it is just one method that we have at our disposal. And what we need to think about before we rush headlong into using the Socratic method unquestioningly is whether or not it's going to be appropriate to deliver the outcomes we want. So this is something that we will talk about in much more depth over the next 2 days, but I thank you, Judge, for raising that point because it really is, again, at the heart of what we're looking at.
So can I then ask Professor Maxino, this will be the last question before we move quickly onto the break, but please, Professor.
Thank you. I have been teaching law since 1997. And I use the Socratic method a lot. After the aftermath of, after Google become prevalent, especially during the pandemic, I have modified though the outcome. I still use Socratic method, but the learning outcome, I have modified it. I no longer ask questions that are objective. Even recitation of cases, I have ceased doing that because they could easily search it in the Google search engine. But I think the questions that I ask are more of application of the law, like which provision of law applies to which set of how do you distinguish this case from this case? What arguments are to be anticipated from all the parties? So it's more of a critical analysis of the law. That way they could not search for the answer. So it's more of a more skill development. You know, I like to teach them the skills to do this as lawyers. Now no longer the content, the law. No longer about cases, because even when they become lawyers, they can easily just they can easily find the case.
Oh, we've lost the sound.
So I still do, but I just changed my I still use Socratic method, but I changed the questions already. They anticipate outcome. Thank you.
Thank you. Thank you very much. So thank you very much indeed, Amanda, and we will move on to the next session before we have a short break and then move back into the thank you very much, Professor. So thank you all very much for those questions, and I'm sure we'll have a lot more over the next day and a half. So I would now like just to do a quick overview of the program before we have our first morning tea break. And the important thing about the blended learning session that we'll be doing over the next 2 days, we'll focus today mostly on pedagogy, ideas behind teaching, and then we are going to have a short introduction to one of the projects that the Technical Assistance Program of the Environmental Law Champions work that the ADB is doing, which is a model environmental law curriculum that was developed as an overview, mostly for the Greater Mekong countries, but now has been extended to look at the Philippines. And the Philippines does already have a rich environmental law tradition, both in terms of scholarship, but also in terms of education and in terms of teaching, as well as cases and materials. And probably within the Asia Pacific region, it has the most significant amounts of materials, cases, some of which have been run by a number of professors here in the room. So we're going to look at that environmental law curriculum, and as part of the work tomorrow, people both in person as well as online will be giving you a little bit of homework tonight, but not too difficult homework, but it'll be looking at one of the modules to develop for the environmental law curriculum. We didn't tell you we were going to give you homework, but like all good professors, we can spring the occasional surprise test on everyone. So we'll be looking at that to try and gain the benefit of your expertise in putting together this model environmental law curriculum. And I'll be running through that after Professor Jonathan Liliebard has identified some of the issues about curriculum design, because it is an important time in the Philippines for curriculum design, with environment and natural resources law becoming a compulsory subject, with the development of environmental law clinics as a requirement. These provide this extraordinary opportunity to bring together this wealth of experience in the Philippines, to mesh it with international standards of pedagogy and training, accepting and understanding some of those comments that Amanda has been able to make. So that's one of the things that we will be doing over the next 2 days. The important thing is we will be having some breakout groups, and so we will be using the tables to work in groups of 5 or a few more. We'll also be breaking out the online people into breakout groups, and there'll be a moderator there, and then our moderators will be also able to call on people to provide comments. And I should also formally welcome Rosalisa Isma Osario, who is here and has been able to arrive, and of course Griselda Mayo Anda, Jyoti, who are the presenters and facilitators with Professor Amanda. And we will have tomorrow a bit of a discussion about environmental law clinics with Joyce Melkartan, a lawyer with Client Earth, who's doing some work on environmental law clinics in the Philippines, and Dr. Georgina Lloyd, who is the regional coordinator of the Environmental Law and Governance Program based in Bangkok for the United Nations Environment Program, and has been a great supporter for the work of the Environmental Law Champions Program. We do hope also tomorrow we will have a sort of a short panel discussion where we will talk about some of the specifics. We've got 6 specific environmental law topics that we will raise and discuss about how those are developing and some of the issues that are being raised. There'll also be an opportunity for you also to share some of your views about how those particular topics are being addressed, some of the important issues that have emerged in the Philippines over the last couple of years. So above all, it is partly important for us to work as a group to get our feedback. And if there's any comments or questions, please come and see me. If there are any issues online, please type it into the chat box. We have got people. We've got Paolo Burro there, wave Paolo, who will be moderating, as well as the tech people in the booth. So if there are any problems online, please let us know, and we'll try and resolve them as quickly as possible. On that note, Angelo, do we have the Environmental Law Champions videos ready? So one of the things that the Asian Development Bank, the Environmental Law Champions program did is develop 3 videos, and we will be playing them later, probably just before lunch. So we'll now move to the first break. So if I could ask everyone to be back in about 15 minutes for a health break, please stretch, please walk around, please have energetic discussions. And for those of us online, we'll be back and commence the next session in 15 minutes. So thank you very much. Have a rest break, a health break. If you need tea, coffee, or other things, please avail yourself of this opportunity. So we'll see you back in 15 minutes, and coffee and tea is served outside in the auditorium. Thank you very much.
Lolos.
Hello, attorney. Mag-update man gud karon sa BIR.
Okay.
Unya ang mangayo ko atong imuhang hatang og ulak to kang Janice tong imuhang COR nga 203.
COR? Saan na siya?
Oh.
Naalang na siguro dito sa office.
Certificate of registration.
Naalang na siguro dito sa Sina Luz. Okay. Wala Ate Gemma.
Okay, mukha lang ko.
Sige,
Unya, mapapirma ko SPA sa imuha para ma-process.
Si ito lang kay Ate Gemma na naman pagtutos ka na tawag na.
Nagpapirma mapirma na.
O kanang pan itan.
Sige. Sige.
Okay. Ay, Luz, katong imuhang i-refer ba? Murag karong summer pa man daw to siya?
Last summer pa, nag-inquire lang siya daan siguro.
Attorney, naka-on po yung mic niyo. Everybody can hear the conversation. Sorry po.
ay. Yung po bistro man kaya dito sa
Ano pa na kaya?
Dito man sa dito ng
Wow.
asa man dire-dire. Ang video. Saan sa man ingon nito? Basit pina-joke lang. Mamit ba ako mag-apply kung lain?
Mag-judge ka.
Si mapiskat. Nasa kanan. Na. Kung napay vacant, mag-fiscal lang. Pero fiscal yata mo apply yan. Wala namang may bakante na si Jose. Saan man natin? Si Kanap ako.
Notice of vacancy na ba yun?
Ha? Nag-notice of vacancy na? Mama. Ay, wait lang. I-chat na ko. Wait lang ako na-chat. Mother. Mother. I-chat ko tap. Ayak na lang. Nagkatingnan. Ayaw na ako. Nagabot. Wala.
Lagyan ako dati. Mag-retire na ka. Year pa daw siya mag-retire tayo. Kami sa lamig.
Kailangan ako mag-retire.
55K. Ang iyahang saldo daw. 65 na daw.
As legal researcher or
as legal researcher?
Kasi si OC.
Si OC man ang kuan. Ay, legal researcher mo nang iyong doctor?
Mother. Ako ay mag-apply din ang mother.
Ako na patawag na.
Oh my God. Inagap. Pero nag-drive pa manggod si JT. Apply siya. Ay, ako nalaingan. Basta malain siya. Oh my God. Mag-apply na kita pagka-judge.
Doon na sa lugar si
So,
mag-judge na siya.
kasi nindot na balay na kasama. Pero kaya ito? Kasi mama? Natin balay siya mama na dapat. Oh my God. Nalupot-lupot ang ito ganina. Court, yung passport.
So,
Court, manakapan.
good morning again. Now we move on into the work phase. No. So Amanda and Jyoti, where's Lisa? Are you up? Oh. Amanda and Jyoti. Okay.
Mag-session. Okay, para mo kung ma-judge ka, di man pwede.
You have a rest.
And welcome back to all our online participants. And just to, in terms of etiquette for online, if it's possible to ensure that if you're online, you are muted. We're very happy to see the photos, but if you could be muted unless you're speaking, that would be great. Thank you very much.
Okay, thank you. Welcome back, everybody. Angela, we're good to move to the next slide. So what we're going to look at in this session is a very quick introduction to environmental law pedagogy with a particular focus on online learning pedagogy. So we're going to expand during this session on some of the issues that were mentioned in the earlier plenary and also picking up some of the points of discussion that were raised. As well as, again, laying the foundations for some of the later sessions that we'll have today and tomorrow as well. We're going to be moving into looking at some of the examples and best practice, particularly with respect to student engagement in some later sessions. But we're going to mention throughout here some relevant considerations for that as well. And I'm going to be joined in this session by Attorney Jyoti, which is fantastic. We're going to be a double act, talking about and reflecting on our own experiences, but I'm going to start the session talking more about the theory from the pedagogical perspective, and then Jyoti's going to move into some examples. So we're right for the next slide, Angelo. So you've already heard me mention the word pedagogy, and I mentioned earlier on that we're looking at the science of teaching or the methodology of education. So it comes from the Greek word pedagogos, which means pedos, meaning child, and agogos, meaning leader. But essentially what it means is the science or the methodology of education. So why are we concerned with this? Why do we care about the science of education or the methodology? Well, when we think purposefully about approaches to learning and teaching, we can improve the quality of our teaching and therefore the learning outcomes for our students. So where students have a positive learning experience and they've achieved the desired learning outcomes, there's a likelihood that they will then remain engaged in that field. And I know you've heard this mentioned already today and in previous iterations of the TTT. But that is what our goal is. If we can improve the quality of our teaching, if we can increase the engagement of students with the subject matter of environmental law, we're more likely to retain them in the field, we're better able to prepare them for practice in that field, and therefore we have more and better prepared environmental lawyers. Sounds simple, right? So, legal education has long been the subject of inquiry into its purpose and methods, and the landscape of literature concerned with legal pedagogy reflects the diversity of interest that it has generated. But for the most part, when it comes to instructional design in law, our pedagogical practice is all too frequently driven by somewhat of a romantic notion of what happens when the professor is in the room with the students, and we tend to basically just adopt and readopt the Socratic method. Now, the Socratic method, and we've already touched on this today, is viewed as superior to other forms of teaching in law. But take a minute to think and reflect on your own experience. Have you ever undertaken any formal training, apart from the TTT, if you've done some of these workshops before? Have you ever undertaken any formal training in legal pedagogy and teaching? Or, like most legal educators, did you learn on the job? And if you did learn on the job, what was your strategy for learning how to teach? Did you by any chance, perhaps unconsciously, just emulate the professors that you had, the ones that you liked, the ones that maybe inspired you? And did you avoid doing the things that the professors you didn't like so much tended to do? I can tell you now that's what most of us did, and it's certainly what I did initially. So we tend to reach for those tried and tested methods, the face-to-face, the Socratic. And over again, it is entrenched in us that this is the way we teach law. This is how you have to teach law. But I'm here to tell you that that's not the case. And as I mentioned earlier in the plenary, there is simply no evidence to suggest that the Socratic method is superior to other methods. It has a place, but it's not the only method of teaching in law. So by thinking consciously about why we're approaching teaching in the way that we are, by engaging in pedagogical practice, thinking about our teaching, we are better placed to deliver an effective learning experience for our students. And that might be using the Socratic method, but there are other methods as well. And in the context of environmental law, so thinking back to not only my plenary this morning, but the earlier remarks from our distinguished guests, when we're looking at the context of environmental law, where we have a complex and constantly changing subject area, where we are living through a pandemic where we've had to move our teaching online, but that the preference for teaching online seems to be an enduring one, employing business as usual strategies, reaching again for the Socratic method in a face-to-face environment, simply might not be adequate as we move forward. So our goal as environmental law educators is to ignite that ongoing passion in our students for environmental law. So what we need to be concerned with is whether or not our teaching practice is actually sparking that flame. Next slide, Angelo. Before we go further, I want to mention briefly the importance of reflective practice as a component of pedagogy, good pedagogy. Reflective practice is really the heart of good pedagogy. Reflective practice involves you as an educator habitually examining the strengths and weaknesses of your teaching, with the aim to understand the underlying beliefs about teaching and learning and improving your pedagogy. When we engage in reflective practice, we're dedicating time to improving our teaching. We're considering our choices of why we have chosen particular curriculum, why we may have adopted certain methods. We consider our student feedback. And I know Jyoti was telling me an example earlier where she made her students watch some sessions about pedagogy so they could better inform her about how they needed to learn. That is all reflective practice, being open to that feedback. You might already engage in reflective practice without thinking about it. The fact that you are here is actually being a reflective practitioner. You are being open to considering and questioning your teaching approach. Now, reflective practice can draw on a number of different sources. There's a number of ways that you can obtain that reflective feedback. It includes our students' eyes and ears, our colleagues' perceptions, our personal experiences, and theory and research. Now, there was a brief handout, I think, supplied with the program materials, and if that wasn't made available, we can make sure it's sent out to everyone, which includes more information about reflective practice and how you can go about it. But I'm going to very quickly mention to you here just some of the basics of how you can be a reflective practitioner and why it's a good component of pedagogy. Next slide, Angelo. So throughout the next 2 days, we're actually encouraging you to keep a reflective journal. Now, it doesn't have to be a lengthy document by any stretch. It can just be a few notes written down on a notepad or some reflections written in a Word document on your computer, just so you can keep a mind on your own teaching practice and maybe some changes or some innovations that you want to do. So the idea is to make some brief entries either throughout each of the sessions or at the end of the day about learnings that you've made, about things you want to try, things that you may want to stop. Now, in order to encourage you to engage in reflective practice, like all good professors, thank you, like all good professors, there's an incentive and we have some prizes, and Matthew is currently holding aloft the prize. So a signed copy of the IUCN Academy of Environmental Law Teaching and Capacity Buildings Committee book on teaching and learning in environmental law, which was co-authored by myself with several other colleagues and scholars in the Academy. So, and don't worry if you're participating online, because we will arrange for that book to be sent to you. So how can you be in the running to win one of these fabulous prizes? You will need to show me before the end of tomorrow a reflective journal entry, and I will make a decision as to the 2 most insightful journal entries. So you can either hand that to me in hard copy, or you can email it to me before 3:30 p.m. tomorrow. So for those of you who are online, feel free to email something through to me or to Matthew. That's okay. And now I understand there's no compulsion. If you don't want to share your reflections, that's fine. But we just want to encourage you to start adopting reflective practice. So, so there will be the chance of winning a prize. So I do encourage you to participate if you can. And that book, of course, includes a whole range of chapters around different aspects of methodology and teaching in environmental law. Next slide, Angelo. So just with reflections and how do we become a reflective practitioner? There are a number of different prompts that we can use. Angela, if you could click the button, these should pop up one by one. I think there's 4 in total. So some possible reflections you could think about. What skills and abilities do I bring? What are my expectations for the TTT? What skills and abilities do I want to develop? And there's one more. Do I have any biases I need to know? For example, am I heavily focused on Socratic methodology that I'm not open to other tools, for example? Could be one example of a bias that you might have. So these are just some prompts to get you started. Things that you might like to think about, to reflect on. Next slide, Angelo. And there's a number of other prompts that you might like to think about. The main issues that were discussed. I made the following comments, or I asked the following questions. I had difficulty understanding these issues. I will research the following issues later. I will discuss the following issues after the next session. This is how I felt about something I read or I heard. I'm going to ask the presenter to clarify this issue. So these are all examples of prompts that can get you started when you're writing a reflective entry in a reflective journal. When you're teaching, you may want to go and write about a particular experience that you had. I taught online today and nobody turned their cameras on, despite trying several tactics to get them to do that. And this is how it made me feel. And this is what I might try to do differently next time. So just some examples of how you could use a reflective journal to think about your teaching practice. Angelo, ready for the next slide? Now, there are 3 models of reflection. And Angela, you'll need to click all 3, thank you. So we have reflection in anticipation, thinking about what we bring to the experience beforehand. What are our goals, our expectations, our assumptions? There's reflection in the midst of it. So while we're actually doing something, what are our reflections in the moment when we're actually teaching? And reflection after the event. So any of those phases is perfectly adequate for you to do a reflective journal entry. Now, I realize that's a very quick introduction to reflective practice, but I want you to be aware that that underpins the heart of being a reflective practitioner, and it's at the heart of good pedagogy. Next slide, Angelo. So the starting point for pedagogy is learning theory. And those at the LEB meeting we had yesterday talking about pedagogy would have seen this slide. It's one that I've used before, and I like it a lot because it reflects that idiom that you may be aware of putting the cart before the horse. So in other words, you're approaching a problem the wrong way around. And when it comes to pedagogy in law and learning theory, it's something that we are always guilty of doing. More often than not, we are guilty of putting that metaphorical cart before the horse. We jump straight into using a particular tool or a particular method before working out whether it actually aligns with the approach. So in other words, we jump straight into using Zoom to do a synchronous online lecture before we think about other tools that we might have available to us. Or we say that the only tool that we can adopt is a Socratic methodology live lecture. So don't put the cart before the horse. Look at the problem the correct way around. And that's why we need to start with learning theory. Next slide, Angelo. So there's an abundant research into theories of learning. And these are informed by discoveries in psychology, in neuroscience and technology. And most recent research is really lending itself towards the fact that learning is quite social and that we're wired for learning in those more social situations. Our intellectual curiosity is sparked in those settings. So these three theories of learning really underpin and guide us to how people learn and how it is that they grow and develop knowledge. And so the three theories are behaviorism, cognitivism, and constructivism. Now, these theories underpin not only online learning, but also face-to-face learning, and they exist on a continuum. So at one level, we have behaviorism, which tells us that knowledge is acquired from low-level stimulus response tasks in a passive manner that is reinforced by the teacher. So the focus here is on learning and repetition, learning some facts and being able to repeat them back to the lecturer. If you've heard of Pavlov's dog, you know, the ringing of the bell of being that associated with rewards and treats, this is a behaviorist approach. We provide a stimulus response cue for our students. Can anyone think of what a good example of behaviorist approaches might be in law? What's an example of behaviorism that we perhaps commonly utilize? And is there a particular lecture approach? So Socratic method, because what we have done is we've conditioned the students to think that they need to memorize a bunch of cases or principles, and that any time we might ask them a question and they need to produce a response. They don't necessarily have had to have thought about or had any deep understanding of it. It's just about that recall of that particular fact. So that's the behaviorist theory of learning, and it has its place without a doubt. It's definitely been criticised as being teacher focused because it emphasises repetition and recall and memorisation rather than deep understanding. But in some cases that may be necessary. Now, the next theory of learning that I want to introduce you to is cognitivism, which views knowledge as more actively constructed by learners, where they start to process what they need to know. So the teacher acts more as a facilitator that guides discovery. So this theory says that learning is not only due to external stimuli, but there's some sort of processing that happens in the mind and the learners become more active participants. They draw on their prior knowledge and they link it to new information. So the mind plays a role in processing information. And we know that our students need to do that. A great example of this in law is where we ask students to apply the law to a set of facts, to a hypothetical fact situation. This is a great example of cognitivism in action. We're giving them some external stimuli, generally a set of facts or some law, and we're asking them to process that information and give us a response. So cognitivism. And so we know that we need that approach in law as well. Now, finally, we have constructivism, and this is where we see knowledge being constructed through a learning community where participants collaborate and co-develop knowledge and experience. So knowledge is contextualized by the learner. They bring their own knowledge and experiences, their thoughts, their opinions, and they make sense of information and a problem. So this theory of learning holds that knowledge is really built upon many different foundations, and the role of the teacher is again that of a facilitator. So learners are much more in control of their learning journey. Now, in law, a constructivist approach might be evident where we're asking our students to critically examine something, to propose a reform solution for law or something along those lines. So these three theories of learning described here provide a framework for understanding how people learn, and they can guide the design and development of learning strategies that will be appropriate for achieving desired learning outcomes. So these theories are useful to keep in mind as we move through. if we want our students to develop a really deep understanding of perhaps an area of law such that we want them to be able to devise reform solutions, and yet we're only adopting approaches that require them to memorize law and repeat it back to us, then we're probably not allowing them the opportunity to really undergo that deep engagement and what we need them to do to achieve the requisite level of learning. Does that make sense? So we need to come back to those theories of learning first. What is it that we actually want our students to do? So when we're talking about environmental law, and I might even, if Com Jojo doesn't mind me calling on her at this point, we had an example given yesterday of some of the learning outcomes for the entire law degree in the Philippines. And Com Jojo, I'm very sorry to call on you without notice, but I wonder if you can come to one of the microphones, if you can remember off the top of your head what some of those outcomes were.
Well, if we go to the Law Reform Act, one of the objectives of legal education is not just to prepare our law students for the practice of law, to make them leaders, to promote the development of our legal system and that one. And if you go to the revised model law curriculum, there is also a listing of the outcomes that we want from our students, that they are gender sensitive, that of course they are leaders and they are problem solvers. So maybe I think that's what Amanda is trying to tell us, like, will Socratic method make our students good leaders? Will the Socratic method allow our student to help in reforming our legal system or help promote justice? Because I think if you look at the Legal Education Reform Act, it also says that we should take care of the marginalized sector of society. So our teaching methodologies geared towards that outcome that we want to see in our students.
Yeah, thanks, Com Jojo. So I think it's really important to keep that in mind. If we set these really lofty goals for learning in our, whether it's at the whole of degree approach or even just the subject area level, if we've asked students or said that at the end of this subject, they're going to know how to reform the law, but we're not using approaches that meet that, then there is a disconnect, or we may have put the cart before the horse. So once we've determined the underlying theories of learning that really should inform our approach, then we can start designing our approach to teaching. And Angelo, we can move to the next slide. So when we think about designing courses, there's a principle of design that I want you to keep in mind. And when Angelo changes the slide, you'll see what that is. And it's called constructive alignment. Now, constructive alignment is a designing principle or a guide for designing curriculum in general that helps us make those logical connections between our theories of learning, between our activities, our learning outcomes, and so on. Matthew, are you able to just see if we can move to the next slide? So constructive alignment occurs when the learning activities that we've asked students to engage in helps them to develop the knowledge, skills, and understandings that are intended for the unit and then measured by the assessment that we give them. So if the assessment doesn't link up with the outcomes, then we haven't achieved constructive alignment. So it's a principle of design that I want you to bear in mind. Angelo, we're right to move to the next slide. And so this image perhaps shows in better graphical form what I'm talking about. So at the first end, we start with our course level outcomes. What is it that students need to know at the whole of degree level? Then we move to the individual unit. What are the learning outcomes at the individual unit level? In other words, what are our learning outcomes for environmental law? Then how are we going to assess that students have met those outcomes? So can you see what we've done? We haven't even thought about whether we're online at this point. We haven't said the word Zoom once. So we're still at the stage of saying, what is it that we want students to know? How are we going to assess that they know those things? Then we look at our learning activities. How are we going to give them the knowledge that they need to know or help them to develop that knowledge in order to do the assessment tasks to demonstrate the learning outcomes? And finally, what are the resources and other content items that will help on that journey? So you can see that when we look for a constructive alignment design approach, we're making sure that we have not put the cart before the horse. Everything should line up and everything is very much deliberately thought about and worked through. So we're going to take a very brief look at these steps before I hand over to Jyoti. So next slide, please, Angelo. So learning outcomes is the first step. How many of you have had experience here with designing learning outcomes for your courses? A few, and maybe some online have had some experience. So a learning outcome is a statement of what a learner is expected to know, understand, or demonstrate at the completion of their learning. And it's very much a student-centered approach. We're not telling the students what we're doing. We're telling the students what they need to do, what they're going to do as an outcome of studying this particular subject. So it's very much a student-centered approach because we want them to demonstrate something to us. We're not telling them what we're doing for them. Designing learning outcomes can improve our course design by providing clarity and transparency for students, but they need to be measurable, they need to be specific, and they need to cover not only content, but also the skills that students are going to develop as well. And those skills and knowledge need to be accessible. They're the things that we're going to assess students on. So Com Jojo talked us through some of the learning outcomes that sit at the level of the whole law degree. If we were thinking more at the level of the environmental law subject, we need to be thinking about what it is we want our students to demonstrate. So that's our starting point. Next slide, Angelo. So when we're looking at designing learning outcomes, we can look at learning taxonomies, and we can pass on these resources to you all so you'll be able to look them up. So the most well-known learning taxonomy is Bloom's taxonomy. And you can see here the hierarchy of the different learning outcomes. So at the base of the pyramid, we have what you might call lower level learning outcomes. So we need you to remember or to recall some basic facts. Define, list, detail, memorize. These are very much our behaviorist types of things, and they have their place, okay? Then we move up through other levels of learning to the top, which is where we are asking students to create new work. And that might be where our devise a new piece of legislation or a law reform solution sits in the scheme of things. Now, it is hierarchical. Before you can understand a concept, you probably need to remember it. So that's where our memorization and Socratic method comes in. To apply a concept, you need to understand it. So that's where our cognitivist approaches come in. In order to evaluate something, you need to have analyzed it. And to create something of your own, you need to have completed a thorough evaluation. So our learning generally moves through that pyramid from the base foundation level to the top. We don't always need to start with lower order skills either. Given that environmental law tends to be a subject that students study later in their degree, we can probably assume a base level of learning such that we don't need to repeat some of those lower order things. If we did that every time, it would become a very tedious and lengthy law degree. So this is why we need to start by considering our learners. Where have they come from? What do they know? Where can we start? So an interesting point for you to reflect on in your reflective journal entry might be to think about the wording of some of the learning outcomes that you could devise. Here are just a few examples of some that I have used. Identify relevant environmental law and explain how the relevant law is applicable to an environmental problem. This is very much at the lower level. Understand, apply. So we're at that sort of lower to mid-level. Evaluate laws against procedural and substantive criteria, or critically analyze environmental law within a particular context. Now we're starting to get into some of the higher order levels. Now, I understand the slides will be provided to you, so you can look this up, but it's very easy to find Bloom's taxonomy online as well. And you can also find resources for drafting learning outcomes. So it's a really important part of pedagogy, irrespective of whether you're online or face-to-face, to set out those learning outcomes for the students. Next slide, Angelo. Once we've designed our learning outcomes, the next point in our constructive alignment approach is to think about assessment. Now, this session right now, we're not going to be talking about assessment in great detail. We've got other sessions later on where we'll talk about that. But essentially, assessment is all about deciding how well students have achieved those intended learning outcomes. Now, you may have heard before of criterion referenced assessment. And if you haven't, what it is basically providing students with the criteria ahead of time as to what they're going to be assessed on. How can they demonstrate certain standards of judgment? So they're predetermined criteria as to the qualities or characteristics that we're going to use when we measure our students' assessment. What are we going to take into account when we judge their performance? So it's really important that we do that so that there is clarity for our students and transparency around marking their assessment. There are also some other design factors that are worth keeping in mind. Is the assessment task authentic and real world? Is this something that students will actually have to do in practice? They're more likely to engage with it if that's the case. Does it prompt the student to develop skills that they're going to rely upon and use later on in life? Again, these are more authentic and real world options. Next slide, please, Angelo. Now, assessment comes in a variety of forms. The two main types of assessment to keep in mind, though, is that we have summative assessment, where we assign grades at the end of a semester. Usually this is what mark a student will achieve for the entire subject. And they can also be formative. They may have a grade attached to them, or they may just be simply to provide students with feedback and guidance. When it comes to assessment in law, what type of assessment do you think we tend to rely upon out of those two types? Summative. And in most cases, we tend to rely on 100% one item of assessment in some subjects. Now, in Australia, for some time, we've been moving away from that practice and having a combination of formative and summative assessment. So there's a lot that has been written about that 100% summative only, do or die exam at the end of semester, and the stresses that that places on students and the ways that it detracts from deeper, more genuine learning. So again, we won't have time to talk about it in this session now, but throughout the next 2 days, we'll come back and think about how you can use a combination of different assessment types. Ultimately, what you need to ensure is that whatever the assessment task is, students have an opportunity to demonstrate achievement of learning outcomes. And this is where I'm suggesting to you that maybe a 100% end of term exam is not the best way for students to demonstrate learning outcomes if we've said that in the learning outcomes, they're going to demonstrate a mastery of law reform, for example. So it's about matching up that assessment with what it is we want the students to know. Next slide, Angelo. So once we've determined the assessment tasks that are going to measure the students' achievement of learning outcomes, then we get to thinking about how we're going to teach our students. That's when we talk about the learning activities that we're going to do. How will students start to develop the skills that they need to do the assessment tasks? Now, there is no single correct learning activity in law. There is a tendency to use lengthier lectures with a Socratic method and maybe some in-class tutorials. But as I've said before today, there is no evidence that this is the best or the preferable option in law. Your strategy should be ideally a combination of your own personal style, but also the learning needs of your students and what is going to best help them demonstrate the learning outcomes that you think they need to demonstrate. So if one of our learning outcomes is the development of oral communication skills, for example, but then we have no activities or assessment tasks where students are required to speak, then there's a mismatch between our activities, our learning activities, and our learning outcomes. So we haven't achieved constructive alignment. Now, at this point, I know we've been racing through the content and there's a lot to take in, but what I'd like to do is hand over to Jyoti, who's going to now take us through some very practical examples from her own practice, which have helped to really break up, I guess, that didactic lecture model approach. And then we're going to have an opportunity in the next session to explore some alternative learning strategies as well that Jyoti has adopted, as well as myself. And then tomorrow we're going to look at even more examples. Following our discussion here, we've also got an opportunity for you to work in small groups. And I know there are plenty of you who have great examples from your own practice that's going to be wonderful to hear from. So Angelo, I think we're right for the next slide and Jyoti's turn to speak.
Can I be heard? Okay. Thank you, Amanda. To all the professors online, I know a lot of you. It's great to see you here. And to all our fellow professors, the deans, the commissioner from the Legal Education Board, good morning. So just to build on what Amanda mentioned about reflection, reflective journal, the questions that actually I had teaching for 25 years is, environmental law and natural resource law is not a bar subject. And the law schools are bar-oriented. So how do I capture my students' attention so that they can be engaged? They're willing to learn, discover new things. So Amanda is correct that you do have to go beyond the Socratic method and then try to be varied. And there's a list of possible options, although one thing I'd like to share as an insight is the journey as an environmental law professor is really laden with a lot of challenges because you want to bring in your own situation in an area. Fortunately, I come from Palawan, which is the last ecological frontier. And what you want to know is how can these lawyers in the future help preserve the biodiversity there? Of course, it's the challenge. Lisa was talking about environmental stewardship, environmental governance. How can they be part of the solution? So these are some of the things that we have been doing. One is this drafting. I've done this face-to-face. So that was a few years back. But fortunately, under COVID, I was grappling with it initially, but with a lot of students still online, we actually discussed a subject about indigenous peoples facing the problem of an extractive project. So then they had to write the Department of Environment and Natural Resources. So the drafting was good, and then they can report back. So that process was good in the sense that they are able to understand what the Indigenous Peoples' Rights Act provides for vis-a-vis the local government code, environmental impact assessment process probably, and the Mining Act. So this, I think for specific topics like example, ordinance making, because some students are very passionate about the fact that you come from an island province, there's so many small islands actually facing fishery issues. So there's a proposal to improve a fisheries ordinance. So that would also be good, so that they then realize that, it's not easy to talk about aquatic pollution or, small scale, large scale fishing, etc. And then to look into what can be appropriate, whether administrative adjudication can be covered by an ordinance. Anyway, those are just samples that I'd like to share. Next slide, please. On the next slide concerning structured class discussion, I had recently an experience online just last week. We had a learning session on the National Inquiry on Climate Change, where the concept of carbon majors, fossil fuels, pushing an agenda before a Commission on Human Rights. And it was great to see students understanding that, okay, there's such a thing as carbon majors. There's such a thing as denial of climate science. And then, the concept of greed was also discussed, plus climate change and human rights, which is also the right to a healthy, clean, and sustainable environment was also upheld recently. So there was a lot of discussions on how can they contribute. So then the class discussion is not only coming from the lecturer, but one insight there is really preparation on the part of the professor. You need to look into what can be most relevant given a certain set of circumstances. So I used in the past, face-to-face, I had a topic, okay, whether it was an issue of dividing Palawan or an issue of mining in a protected area, or whether the island provinces of Visayas need to be clustered together, so that you can facilitate more effective environmental management. Those were things that were raised, but that was face-to-face. Under online, I was able to show this learning session so that they were invited to a sort of webinar. Okay, next slide is I think the next slide, please. The free form class discussion. Here, students can be assigned to bring with them a topic. Okay, whether it's the dominance of plastics now in the environment and the fact that there is still continuing difficulty on how to address it, the role of business, the private sector. So the reality check vis-a-vis what laws we have. So then there can be a debate, of course, but what I would appreciate is that they then understand what Ecological Solid Waste Management Law or Clean Water Act or Clean Air Act or EIA, Environmental Impact Assessment, then it becomes real. There can be issues, of course, but in a classroom, you can agree to disagree. There can be disagreements, but you can also agree to disagree. That, okay, we can identify that this is an area that needs to be worked on. Perhaps when I become a lawyer someday, I can help a local government unit or a national government agency. So those are insights we want our students to actually articulate so that we can be sure that there is something that they have gained from the course. And then the last, I think, is on, next slide, please. A brainstorming, yes. This I actually like. In the past, I used to bring meta cards and cartolina in my classroom. Of course, this was a few years ago with pentel pen, so that we can see the meta cards. And the brainstorming there is, what is the environmental situation in the Philippines or the situation in Palawan, example. And then they can identify, and then another focus question would be, what would be the good practices or initiatives that you see happening in the Philippines? What will be some ways forward? But then online, I was able to use menti.com, Matthew. I learned menti.com from you so that it was interesting. So then you see colorful answers there and also insights on what's happening on the ground. And then the students explain. Each one of them are able to explain and discuss further whether this problem is something that can be remedied, okay? And then one interesting insight there is the comment that the cases that we have are not enough to be able to strengthen the push for a sustainable development agenda, meaning there is need for strategic environmental litigation. And that's a good insight. How can you shape jurisprudence so that you can invoke more cases when you file environmental cases? Because at the moment, with all due respect, the jurisprudence is not that many compared to rape cases. If you look at environmental jurisprudence, even with the Indigenous Peoples' Rights Act or Wildlife Act, protected area. So I think our ultimate goal should be that they can contribute in the future to change behavior, push for policy reform, and become part of the ever-growing effort of pushing for sustainable development. So I'll stop from here, Amanda, and give it back to you. Thank you.
Thanks, Jyoti. If we can move to the next slide, thanks, Angelo. So Jyoti has just taken us through a couple of very practical examples that she implements both in person and online to just depart from that very traditional didactic lecture model. So rather than it being all about her as the professor imparting wisdom, she's used some of these strategies to allow the students to come into the conversation a little more. And as we heard from Jyoti, there are tools available online, things like Menti, Padlet, and we're going to give you some of these examples in a later session where we're focused specifically on online tools. There are tools that you can use to bring the students into that conversation and just make that lecture experience a little more conversational. So this was just to really just plant that seed and introduce you to some of these other learning activities that you can adopt. So ultimately what we're looking at is our overall learning environment, which incorporates the educational approach, whether it's teacher or student-centered, what the characteristics are of our students. Are they freshmen? Are they final year students? Our cultural context, and also our physical and virtual presence. There is no one single way of creating an effective learning environment for law, and what works for one cohort at one university may not work at a different university. What works for 1 year of students in a class that you're teaching may not work the next year. So it's all about taking these broader contextual factors into account and questioning and reflecting on your approach. So what we need to be aware of, if we're adopting a constructivist approach because we perhaps have set learning outcomes that are applicable to that approach, we need to bear in mind that our learning activities can extend beyond the classroom. It doesn't have to just be the lecturer presenting content. We may ask the students to come into that conversation. We might get them to go outside the classroom to engage in deeper learning. So don't discount other areas where students can obtain knowledge, particularly if you're setting them to do reflective activities outside the classroom. So the learning environment is really the setting or the context where learning takes place. And it's all of those other factors that really make up the experience of the student. And at the heart of that experience is whether or not students are engaged. And the number one thing that I've heard in speaking to your colleagues, particularly those from the LEB, is that with the move to online teaching, we really saw a rapid decline in student engagement. Now, what I can assure you is that it is possible to build student engagement online. We just need to use different tools and different practices to what we would have utilised in the face-to-face setting. Next slide, please. So student engagement is something that we're going to delve into in much more detail in a later session and in tomorrow morning's session in particular. Really, we just wanted to highlight it as an issue at this point and give some examples from Jyoti's practice as to how she has built student engagement. But so I really don't want to dwell on this now, but I just want to put this here to really put a pin in it and to get you to start thinking about engagement as encompassing three very particular areas. Student engagement is a challenge in all learning environments. We saw pictures before of empty lecture halls where no one was showing up. So it's not just in the online setting, but it is particularly challenging in the online setting. So we need to think about all the ways in which engagement is built. Traditionally, we looked at student engagement through a behavioural lens. In other words, did they come? Did they show up to class? And this is because in part, student participation is a strong driver of engagement. But more recently, scholars have conducted research and have found that emotional and social factors are also important components of engagement. And these are the factors that influence student investment of time and effort to actually participate in learning. So what we're going to talk about in more detail tomorrow is this community of inquiry model. And at the heart of that model are three types of presence. We have cognitive presence, social presence, and teacher presence. And we need all three of those presence types in play to have a meaningful learning experience. So we're going to spend a whole session on this tomorrow. Don't worry if you miss it now. But for now, just be aware that there are these three ways in which student engagement is built. So it's not just about whether or not you have a lecture that they can attend or a learning activity that they can participate in. That's what we would call cognitive presence. So have we set up the factors that allow them to undertake learning? Do we have learning activities that stimulate and engage them? There's also social presence. Have we set up a community where students identify with their peers and are therefore more likely to participate in learning activities? And finally, and most important for the online learning context, is teacher presence. How visible and engaged is the teacher? Research has indicated that that's the number one factor that drives student participation and engagement in online learning. So how do we establish ourselves as teachers in the online learning environment is a really critical issue, and it's something we'll spend a lot more time on tomorrow. Next slide, Angelo, please. So the purpose of this session was to introduce you broadly to environmental law pedagogy. And I understand that this is very much a whirlwind run through the theories that apply. We'll have more time to talk about this and to tease out some of the issues. And what we really want to be able to do now is to hand over to you to start sharing some of your experiences. Now, the other thing I want to draw your attention to at this point is an upcoming resource that's being developed by the TTT project team. And it's an e-learning course on environmental law pedagogy. So that's being developed at the moment, and it will be available online before the end of the year. So if you are interested in understanding more, in much more detail, some of the theoretical concepts that I've taken you through today, there'll be an opportunity for you to undertake this course. It's going to be available through the Champions website, but you will all be emailed information about that in due course. And in that course, we will understand and work through in much more detail some of those theoretical concepts, particularly as they apply to online pedagogy. So if you do have anything that you would like to see included in that course, please feel free to come to me in the break or send me an email if you're one of our online participants. We'd love to hear from you and help shape that model. So for now, I think I would like to hand back to Matthew to explain how the next session is going to run. Unless you wanted to do questions, but I think we're probably at a point where we need to move on.
So thank you very much. So we now are going to break into have a little breakout groups, and online we'll be breaking into six groups. But before we do that, we're going to distribute. So if people could get into sort of a group of about 5 people, that should give us maybe. Yeah, I think each table can be 5, and if you want to be 6, that's also good. And online, we'll be breaking you into a few groups just after we've explained what we're planning on doing. So for the next half an hour, we're going to do a quick sort of sharing, if you like, of some of the experiences that you used either online or that you use in person now that we're coming back. Just to identify what are the key things, what are those methodologies that you currently use. So within the online groups, you'll be broken up into groups of 10. And if we can, then the idea is to identify within those groups, and if someone could volunteer themselves to be a reporter, just to identify a number of key methodologies that you are using online or you used before in person that you think are very effective techniques. And these might be the ones that have been discussed. They might be new ones. And we've already had some, we had Judge Shirley also talked about, asking students to identify problems with proposed solutions. So please sort of identify those things that you have used, and also perhaps you can also say whether it was really successful or not. So we'll do that for the next 30 minutes. And then we'll come back and our trainers will choose some people to do short presentations. So online, Angelo, you can automatically assign those participants to the 10 rooms? Okay.
Well, we were within 45 minutes.
Yeah. They stuck to my 10 minutes.
Jumping and joining one of them.
Yeah. Yes.
Even if I don't put it out.
Hello, everyone. May we ask the participants in the main room to please proceed to your breakout rooms po. You may click the breakout room function at the bottom of your screen and then join po dun sa inyo pong ano.
Are you set up as an administrator?
I think we still have Attorney Rivero, Attorney Pascual, Attorney Dawaton, Attorney Tibayan, Laneses, Olendo, Saganay, Oyos, Attorney Irene, Reyes, Basiloy, and Attorney Joshua Ngayaut. Please join the breakout rooms po by clicking the breakout room function at the bottom of your screen.
Walang audio yan. Ay, walang presentation yun. Okay.
Okay, so can we give the three cups?
Okay, do you hear some audio in our online audience?
Yes. Yes, Matthew, we can hear you now.
Great. Thank you, Dean.
So I will go up so they can see me also.
No.
Hi, I'm Rodel, and I said earlier, I am very lucky because my group is very active in not only in the field of environmental law, but also in the teaching of environmental law and law. We have from the Department of Environment and Natural Resources, of course, Attorney Nor and Attorney Ilak, and of course, for a dean of a college of law and former judge, environmental law judge, environmental court judge, Judge Jo, and of course, from the Senate of the Philippines, Attorney Dodi. And we are very happy because our group's discussion is very fruitful according to the good judge here. This is one of the most fruitful focus group discussions that she ever had in her experience. And thank you. And to speak about experiences and reflections on teaching environmental law, we thought of first, of course, we know that environmental law is such a huge topic. So there is a need to first and foremost divide this into different classifications. So we have the blue laws that would discuss about the marine laws and all the related laws there. The brown laws, which would include, for example, mining, environmental impact assessment, the green laws like the forestry laws, land laws. For example, on the brown laws, this is just an example, okay? So we have this set of laws, the PD 1586, RA 9275, and all the rest of the laws here, including, of course, the local ordinances that may be relevant to all these laws. So, you know, we have an expert from the DNR here. So we're always ready. So RA 9003, for example, the ecological solid waste management, and all these laws, including the ordinances in the provinces and the municipalities, and even in the barangays that may be included in this topic. But this is only about the brown laws. And as we are saying, there is a need to orient or reorient the students, not only in the law school, but even in, especially more in the graduate school of law, where I am proud to be part of in the San Sebastian College Recoletos, Manila, because we have a program with the different 6 law schools. So, and our students are professors mostly. So I think this is a good approach for the professors to divide the environmental laws. Okay, so going further to the specific methodologies, okay? So as to the methods of teaching environmental law, after classifying all these laws, we have 3 points. One is experience, number 2, dialogues, number 3, create. All these methodologies will be subdivided into different tools and a combination of different approaches as well that may even include online, offline, so face-to-face or blended type of learning. And number 1 is experientials. We provide experience. So imagine a class where you are in the subterranean river in Palawan. So the picture can paint 1,000 words or hear 1,000,000 stories. So you don't need to explain more on the first day of meeting, right? So we go out of the classroom, we do field trips, we see the pollution, we do ocular inspections, we see videos, for example, online. We have lead points. The professor here is not only a tourist guide, but also a teacher there talking about specific points, specific facts, data, issues, and others. That would mean also going into different programs and projects, like you visit a mining site. So we go, for example, to a finished case of a specific mining corporation or an ongoing issue that would lead the students to think and rethink about the possibilities of migrating from law books to experiences. So this is what we call experiential type of methodology in teaching environmental law. And we go to the next, that is dialogues. So from looking at this environmental issues, topics, tourist spots, we talk about people. We talk about our students. Our students talk among themselves. So we refer this from chairs to auditoriums, from person to focus group discussions, to speaking in front of a larger venue, an auditorium, for example. So we have individual dialogues. Students A and B would talk to each other about this particular topic given by the professor, and then the students, after their personal dialogues, they will present it to a bigger group, and then the bigger group will present to a larger group, to the auditorium. So we have here structured discussions. We have here students discussing and the experiences about the law and spinning all these aspects of the brown, the green, or the blue laws that we are talking. And based on these dialogues, the students will experience not only their own personal experiences, but will have a feel of how others experienced in their own practice or in their own communities or in their own readings of particular laws. And the third one is create. Here we talk about not only discussions, by the way, going back to the dialogues, the DNR would require the information and education education campaign materials from different companies. So here in the dialogues, we'll also bring, while we are going to the different areas of the companies, for example, a mining site, the companies will also present their own experience, the law, their own experience, the mitigation actions that they are doing there in their sites. So they can look into that. And lastly, create. So after all the discussions, they'll be able to present papers, journals, legislations, proposed legislations, ordinances, and of course, publications, discussions, assessments, and proposed new reforms. That would be all. Thank you.
Thank you, Dean. And then can we get, okay, I called them already, and then one online. So from Attorney Rebelinda. Pasensya na, na-extend.
Good afternoon. It's hard to second a very impressive presentation. And from our group, I am very lucky, like the first speaker, to be in a group with legal experts in environmental law. I think I'm the only one who's not teaching environmental law in our group. And just like the previous group, their method of teaching environmental law is also experiential, dialogues, and create. Professor Galahad and Professor Osorio are very creative in teaching environmental law. I didn't realize that law can be taught in a manner that tickles the imagination of the students and catches their attention, so they pay attention to the lecturer. So what I learned from Professor Galahad is that he applies environmental concepts. He encourages his students to sell and recycle the things they have at home in junk shops, and they use this as a fundraising activity. And then the money that they raise there is what they use for their trips to environmental sites. This is also the same method that Professor Osorio applies to her students. She allows them to go out to the community. So by going out to the community, the students are made aware of what is going on and what is the problem with the environment. For the other environmental law professors, their main challenge is that the environmental law subject is not a bar subject. So sabi nila, it's common to hear students complain that for a 2-unit subject, which is not even a bar subject, professors demand so much. However, at the end of the semester, they realized they learned more from their professors in environmental law. Kasi nga, siguro that's the way to invite attention, be creative. Si Prof. Galahad, sinasabi niya, he allows his students to watch Pocahontas videos. He gives them questions, trivias, and whoever can answer that question first correctly will be exempted from the recitation. So I found professors being able to be flexible and teach environmental law na kasi to us, it's a boring subject to those who are not interested because it's not a bar subject. Then for the rest of us, of course, for our dialogues, all of us use the Socratic method in the recitation. Then, in the create method, most of us are using the assessment, the Google Classroom, and we also, for Prof. Osorio, she asks her students to make reflective journals during lecture, then readings. I think they use the same method, Prof. Galahad and Prof. Lisa, because Prof. Galahad also asked his students to read books and review them. Then he asked a basic question for the students to answer. Was justice achieved? He also encourages his students to attend public hearings in the Environmental Management Board. And the students are excited because at the end of the session, they will find their names as attendees to the hearings. So basically, that's what we discussed for our group. Thank you.
Thank you, Professor. And I think the last, we will get an online, a group from the online, Matthew.
So I think we have like Group 1 Attorney Nebs Mindalano. Attorney Mindelano, did you want to?
Yes, good afternoon, everyone. Um, Unlike the previous reporter, I just have a very simple slide to share. So I will now share my screen. I hope you can view it already. All right. Okay, so this is very, very simple. And indeed, the first group to report is a tough act to follow. I was told by Gab that we can share for about 3 to 5 minutes only. So my group mates are Father Lem from Ozami City or Misamis Occidental here in Mindanao. Then we have Attorney Marge from Butuan City. Then Attorney Jazz all the way up north from Ilocos Norte. And myself, I am here in Iligan City right now, also here in Mindanao. Okay, so we have a very fruitful discussion, and we talked about the methods and the approaches that we employed in teaching in law school. Actually, in our group, there are only 2 members who are teaching environmental law this semester, and that is Father Lem and Attorney Marge. No, and I was able to teach before, also Attorney Jazz, but that was pre-pandemic, and the public health crisis indeed spawned variations in teachings. And so if you can see right now on my screen, I use these terms which are peculiar in the revised law model curriculum. I took interest because how do we, kanina nagtanong ako sa group mates, I asked, how do we brand or label this one? The first group used also those 3 terms, no, in describing the method of teaching by the members. In our case, no, we use again the Remulax terms there, no, so which is an easy reference. And these 8 teaching methods employed by this semester, most especially by Father Lem and Attorney March, is in combination. So as we discussed also, no, this is not only unique, or our experience or our method is not only mutually exclusive to teaching environmental law, because it's also applicable to other subjects, although there are certain peculiarities when we teach environmental law to our students. So anyway, for our teaching method, we use Socratic, the lecture method, problem method, research method, collaborative method or interactive method, the experiential method, and the field action project. So you can find these terms in the Remulax memo under lab. So Socratic, because this is something that admitted by my fellow faculty members in the group that they cannot do away with, and they are employing the Socratic method or some of these methods in a blended platform right now, face-to-face and remote or via the online platform. So lecture, because lectures are also conducted, and then problem. Our faculty members in the group indicated that they make their students identify their problem in the community they are in and to identify solutions to that problem. I will be sharing the unique and specific experiences of the professors in our group for this one. Research, because in identifying the problem, they will be called to actually research or take a look at what can be done, of course, including the pertinent and applicable laws in solving or helping the problem that they were able to identify in a community, which is, by the way, done through a field action project. They are actually exposed to certain areas. They are made to do some immersion in localities or communities. And then they also do collaborative or interactive learning method or a learning modality at that, because the students discuss this by group, no, what they can do in order to provide a solution not only to the community, but they elevate this to the specific government agency or the local government unit that can address the problem identified. So which is overall really experiential or clinical in character. So I'll now be sharing to you the specific experiences. I'm not sure really if this is understandable on your level because this is something that I typed in the course of the discussion. So,
Attorney, we have 1 more minute and then we'll need to break for lunch. Thank you.
oh, okay. Just very
Sorry.
quickly. Yes, no problem. I'll be done in a minute, I promise. So Father Lem, he actually asked his or made his students, they had an exposure in Mount Malindang and Lake Duminagat. So there were several IPs are constituents. So the students were made to identify the interplay of IP laws, constitutional laws, environmental laws that are that can be gleaned in the situation there. And so they have their legal aid clinic. Same with Attorney Marge. They have this the ULAP. No? In Ozamis, it's the MULAP in MU, Misamis University. In Butuan, it's ULAP, which Commissioner Jojo was, of course, one of the forerunners before. And I think he's also supporting this as the former Dean of Urios. So in Dinagat Island. So they were not prevented, though this is a remote island, to talk with stakeholders or the key persons there because they use the online platform for this. So the students were made to design the activity in the implementation, no, of helping the community, not only helping the community with their problems. Attorney Jazz, no, again, is interested in joining the seminar, although not teaching this SEM because she wants to learn the new methodologies. In my case, I wasn't able to write down because I was the one jotting down. But similar, when I taught that before, it's a combination also, except that it was not utilized via the online platform. So I hope that we were able to share something substantial to all of you. Good afternoon.
Thank you, Professor. So for all the groups, can we give them 3 big claps? Thank you. And we break for lunch and we go back at 1:40. Is it okay? Bye for online. 1 hour break. Thank you very much.
So just to let you know, lunch is in the ADB podium. So if you follow some of the ADB staffers and anyone who was here with the LEB, Gab, you can show people where it is. Lunch was where we were yesterday. So thank you.
check. Hey, hey. Hey, hey, two. Hey, two, two. Check, check, check. Hey, check, check. Check, check. Hey, check. Check, check. Hey, hey. Check, hey, check. Check, hey, check. Check, hey. Hey, check, check, two. Two, two. Hey, hey, two, two. 2.
start in about 5 or 10 minutes when we get back from eating the very nice ADB lunch. So thank you very much. And for all our online people, hello again. Hope you've had some opportunity for lunch and charged up with good energy for this afternoon. Good afternoon. Welcome back. Yeah. Shall we give the lunch 3 claps? Does the lunch deserve 3 claps? This is the way we get. We also did the round clapping as well. So I remember those. So we're going to go back to our online people. Are you hearing us online? Good to see you. So we're going to go back and do 2 more groups online and then maybe 1 more from the in-person. So I'll hand it over to Attorney Jyoti.
Angela, how do we online participants here? Because we need the what group from the online participants would like to report? This is Normie. Okay. Due to lack of time, can we request for 3 minutes? Is that okay? Presentation. So who will report? Okay, group 3. Can we have group 3? Attorney Erwin. Attorney Erwin, I saw him.
Yes, hello.
Okay, you have the floor now.
Okay, can I share my screen?
Yes po, attorney.
Teka lang.
You can proceed, Attorney Erwin.
Yes. Ayun. Don't know if you can see my presentation.
We can see it. We can see it.
So we are the group 3. And as much as I wanted to have this on a PowerPoint presentation, but due to the lack of material time, so I'll just present it this way. So we have actually identified 3 methods in our group. First, we have a supervised action research. This was coming from Professor Normita Batula. So the students are given task of researching specific local ordinance, resolutions, or national environmental law, which is a cognitive approach. The example of this is the Republic Act 9003, a local ordinance involving solid waste management. The students are grouped and tasked to read the local ordinance, resolutions, or environmental laws and analyze them and share their learnings in the class. Then the prof provide insights on the practical action research. Number 2, we have the video materials through PowerPoint presentation. This was presented or given by Judge Michelia Cappadocia. The PowerPoint presentations are given in advance to students, and there are questions in that PowerPoint presentation. Example is, why are vehicles required to have emission testing? And why is there a need on environmental impact assessment prior to operation for projects considered environmentally critical? Then the learning outcome, the proposed outcome or issues to be resolved by the students. In that way, the students are given the chance to interact and evaluate the problems presented in the videos. This is presented before the start of the class or session. Also, the judge share she also conduct problem solving based on the video presented at the end of the session, where the students are given a chance to analyze and assess problems, as well as provide solutions based on the research and group sharing. And according to Judge Michelia, the recitation is not graded because it makes the students nervous. So last is the actual student participation on Crown of Thorn collection and site visits. This actually, I done this before last semester, wherein the students were given actual participation in the Crown of Thorns collection in order to expose them to the actual problems involving some environmental laws. Then at the end of the session, students share the reflection. Well, we would like to focus the presentation on the students' participation on the actual happenings on the ground, because by conducting the methods presented, that is through the supervised action research, the video presentations, then the actual site visit, students are given insights on the existing problems, that the students may not see the problems as a sham, but in fact, they are really existing. So the conduct of the crown of thorns, the quick view of the status of the health of our corals will make them realize that the climate change, that it exists in not just in books, but it is actually happening and a threat to all of us. So also in the presentation is the degradation of marine life, the poor condition status of our corals, as well as the marine life. So we emphasize the need of students to actual participation if we wish to have an environment of or a community of environmental law champions, and it starts in class. That would be all. Thank you.
Thank you, Attorney Erwin. And then we will have group 6. Attorney Mylene. Thank you, Attorney Erwin. Attorney Mylene, group 6.
To share my screen, please. Thank you. All right. We talked among ourselves regarding how we effectively would be teaching environmental law or the conduct of classes online nowadays. So our group members are Judges Teresa Camanong, Ana Rica Reyes, Attorneys Ira Condor, Christian Lee Ramirez. So we have discussed, we had a very good discussion that these are the ways of how we are teaching in our respective law schools. So we conduct reporting, wherein we encourage, we divide the members of our classes into several groups, and they are very creative reporting, wherein they would just not present provisions of law anymore, but regarding videos which we would not unearth ourselves. And then there would be a lecture after each reporting to tie the loose ends with matters not delved upon by the students. We also have environmental projects initiated by the students so that they could own the project themselves. One of us would share that they had pre-pandemic, they had field trips. They went to Baler and had bonding with nature, along with bonding among themselves also. There would also be the requirement of making our students write reaction papers, and then Judge Kamanong would let students have the report visits and reflect on that after. The watching of videos and movies, and of course, the conduct still of the Socratic method being one still of the effective modes of imparting knowledge to our students. So the teaching of the natural resources and environmental law would be an advocacy on our part. That's why we love teaching it. Even before some of us joined the bench, we even according to Judge Reyes, she was a struggling new lawyer then. It was her love for the environment that kept her having such load in her law school. So the environmental projects that they've undergone, several of us would be coastal cleanup, those in nearby coastal areas, tree planting. For example, here in Baguio City, we have tree planting activities pre-pandemic po. The conduct of webinars nowadays, because we are limited by this pandemic that we're having. So recently, the School of Law of St. Louis University conducted a webinar on renewable resources naman. The conduct of IECs previously, before the pandemic, some groups of students would go to high schools and conduct information educational campaigns on the environment. And of course, in our own little way, the conduct of recycling, reusing, and reducing pollution would be imparted to our students. So yan po ang output ng group namin. That's the output of our group. Thank you very much po and good afternoon.
Thank you, Attorney Mylene. And for our last group, can we have the group of Commissioner Jo? We can hold it.
No. This one will exhibit team teaching. So may I request my teammate or we can teach in teams. So my team here, my teammate is Prosecutor Go. Help me, Prosecutor Go. Naku, nagkamali pa ako. So I thought na hindi na kami mag-present kasi nahiya kami sa group 1. Bakit naman ganun kayo mag-set ng standards? Napaka-high. Nawindang tuloy. Parang nawala lahat ng ano namin. No, but you're inspiring. Very inspiring. So as an introduction, our group is really a group of learners. We're all here to learn from all of you. So I think it's a good way to end the sharing. Kasi we're only given 30 seconds. Okay. So, we start with Professor Dicky Salazar because he really emphasized first that there must be a basis. When you teach, there must be the foundation. The foundation, as he suggested in his teaching, is really the basis of climate change, because you must have a foundation when you start teaching environmental law. And what's so good with the sharing of Professor Salazar is that they don't have a standalone environmental law subject, but they are incorporating it in commercial law. Isn't that great? No? Like our commercial law students will always have an environmental law perspective. Okay, so they start with an enumeration of the different laws and they integrate it, and they go into experiential learning, like in applying for environmental compliance certificate. No, that's one of the examples where experiential learning is used, no, in teaching ECC, how the concepts and the guide and the rules on ECC. Now, if you can see, most of our learning methods or teaching methods are really experiential. And here's another one, experiential, that's mine. In my other life, when I was still a teacher in environmental law, what we did was really experiential. Like, we only had a very few lecture part because it's a problem approach in teaching. There was a problem in our area, so that was what they were supposed to do. And the end part was really to draft an operational plan for the Protected Area Management Board of Agusan Marsh. Director, sana tingnan mo yung pambi doon sa amin, ha? Wala na ako doon eh. Sige, nagsingit pa. Okay, and then of course, another experiential learning from our Commissioner Lawrence. Commissioner Lawrence kasi is very much, although he did not teach environmental law, but he was the Chancellor of Tawi-Tawi. And so he was really very much exposed to the environmental issues in the community. And they also had teaching activities and he used, of course, Socratic method. And then using testimonies of the fisher folks there and pictures and videos of the areas that have already been destroyed and abused. And of course, lecture. And then, of course, this is from Professor Noel of Notre Dame. Again, experiential learning and very focused on the issues in the locality. And also, they go into collaboration with the different stakeholders in the community. And this is what is beautiful. He asked his students a question. What is the act that you are most guilty of that has affected the environment? Isn't that something that we should also ask ourselves? And now, Prosecutor Go, it's your turn.
In continuance, good afternoon, everyone. I am Prosecutor Michelle Go. I am the Deputy City Prosecutor of Pangasinan. I am happily married. My wife is happy. I am married. I've been a prosecutor for 14 years, and I've been a law professor for 18 years. Although this is the first time that I'm handling environmental laws, our group in the DOJ has been training our fellow prosecutors for the past 3 years. We launched our first training before the pandemic, and when the pandemic hit, we tweaked our modules into online. And then recently, we tried the hybrid. Part synchronous, part asynchronous. And then because of budget restrictions, we have to modify again our modules to be online again, to be conducted November 14 to 18, I think. Hopefully, matuloy din yun. Now, for my class, I introduced the blended learning. Ano yan? Blended learning. As mentioned before, there are three laws. All environmental laws can be categorized or classified into three: the blue laws, green laws, brown laws. And I added the fourth one, the what you call the rules on procedure for environmental cases, ROPE or RPEC. Okay, so that my student will have a holistic understanding of what environmental laws is, because substantive law is not enough. You have to teach them how these laws can be enforced through courts. Okay, so blended learning, how is this? I introduced the peer learning. So I distributed the topics among my students to be reported on. After the presentation of the reporter, I will give the other students the opportunity to raise questions or to clarify some matters, and then we'll have a peer learning activity. And after that, I try to process the entire activity by highlighting the strength of the report and the highlights of the issues that were resolved during the plenary. And then I'm going to interject my own inputs. And that's it. That's the blended learning. But seeing all the outputs of the reports, I think I'm going to incorporate some of them. Ang ganda. Thank you. Thank you very much. Half day, I've learned so many things already. Thank you.
Thank you. Thank you. Thank you. Thank you.
Can we give the three groups 3 big claps? Thank you very much. Listening to all the reporters, it actually articulates a lot of hope, that there is hope. The creativity, the flexibility, the preparations, and the passion for teaching. So to all the online professors and the professors here, we will say again, mabuhay. Now we are at the next session. This is the 2:00 session. And if you look at your schedule, our professors, we will now discuss. There will be an introduction of the draft model environmental law curriculum. And we are pleased to have our senior lecturer from the Australian National University, Jonathan. I could not pronounce his name very well. Lilleblanc. Am I correct? Okay. And I'm glad to have known Jonathan. He has a PhD and JD from the University of Southern California and a Bachelor of Science from the California Institute of Technology. He lives in Australia, okay, and works as a senior lecturer at Australian National University. I hope I'm clear. And he has done field research on the rule of law in Myanmar and has published scholarship on human rights and environmental issues in Southeast Asia. And is a member of VARS international groups like IUCN and ICOMOS. So this session as well, in addition to Professor Jonathan, we'll also have Professor Matthew Beard also talking about the, did I pronounce your name correctly? Okay. I am very conscious about the names because because names are very important to every person. Okay. So then is Professor Jonathan here? Okay. Good afternoon.
Hello, how are you?
So you have the floor now, the platform. Okay.
Okay. So mabuhay, everyone. Good to see you. So I'm not Filipino, and I don't know Tagalog. So even though I look Filipino, but yeah, I'm happy to say I was promoted, so I'm now associate professor. So that maybe helps some of you in terms of the discussions as well. I have PowerPoints prepared, and so Angelo, is it possible to have the PowerPoints up, or should I share the PowerPoint?
If you have your presentation, Jonathan, do you want to share?
Okay. So maybe I'll just share it on my side then, and then that way we can just go together. I will just preface everything that I say with a commentary about all the discussion so far. It seems like everyone is having a very healthy and lively discussion about pedagogy and teaching and content about international environmental law or environmental law. And it's very good to hear this. Oh, let me just, that's not, oh, here we go. Okay. And there we go. So everyone can see the
So
presentation now.
Jonathan, that's just in presenter mode at the moment. So
let me just I'll try this again. Okay, it's just, it's indicating it's taking a little time to present.
I think we've got it now, Jonathan.
Oh, okay. All right. So we'll just go with that then.
I think Angelo might be driving it from our end.
Okay.
So you may just need to give a prompt when you're ready to switch to
Okay.
the slide.
All right. So just go ahead and go to the next slide, please. All right. So so I think everyone has had a very healthy conversation today about the content and the pedagogy for environmental law. And my goal is not to replace or substitute anything that's been said before. Instead, what I really want to do today is to help everyone find a way to coordinate your collective discussion and your collective insights. I think everyone has made very valid points, and I think that everyone's perspectives are important, but maybe there is a way to organize our thinking. I think one day is too short a time to make a decision that is good for everyone. And in terms of generating a curriculum for environmental law for all the law schools in the Philippines, I think it's going to be quite a challenge. And it's the kind of thing that will probably require more time for everyone to have conversations about, what they think is appropriate. As much as different law schools have different perspectives about environmental law, and each teacher has their own approach to teaching environmental law, I do think that there is a challenge in the sense that there are shared concerns about the environment across the entire country. And I think that there's also shared goals about what we all want to see in terms of students, law school students who graduate and become practitioners of environmental law. And we also have expectations about the kinds of students we want to produce as members of society and as human beings after law school. And so it's just a matter of trying to come together, find consensus, and part of that process is to try and organize our discussions. And so what I've done here today is provide a framework to kind of help organize the different thoughts, to give it some kind of clarity and allow everyone to get a better sense as to what the points of disagreement are, and also what the points of agreement are. And specifically, in my mind, and the experiences I've had in helping set up syllabi and curriculum in different subjects in Southeast Asia, as well as Australia and the US, you can generally distill things down to discussions about curriculum placement, discussions about specific content in what we include in a given semester or a given program, law school program, and then also discussions regarding pedagogy, which is what Amanda has been leading all of us through today. So Angelo, just go ahead to the next slide. the first thing that I want to get to, and I think this is an antecedent issue or an antecedent topic to a lot of the points that everyone has made today, is that when we're talking about teaching environmental law, a lot of our expectations, a lot of our decisions are actually affected by larger issues in our law school programs. And what I mean by this is that there's only so much time in a law school curriculum, right? There's only so many units available, or so many units required for a student to finish and graduate. And it may vary depending on whether it's a JD, a JSD, an LLB, an LLM, or this kind of thing. But we know we have a finite amount of time to promote environmental law for the students. And the question is, given everything that we want to discuss with environmental law, how do we fit that within the finite time that is available with students? And how do we do so in a way that doesn't infringe upon the other law school requirements that we place upon students? And so here, I've listed some curriculum issues that were raised, in particular regarding the topic of teaching the Anthropocene. So in the Law and Society Association, there was a movement to promote the instruction of the Anthropocene within law schools in Asia. And I think a lot of the debate raises points that I think are critical in teaching environmental law. So it's a question of, do we want environmental law to be treated as a discrete course, or do we prefer that it be pervasive, that we embed environmental law discussions in other subjects or other courses? I think some of you already mentioned that there's a point of disagreement between doctrinal approaches versus interdisciplinary. Environmental law, by its nature, ties into environmental science, environmental politics, these kinds of factors. But the challenge is, do we leave those particular aspects for other parts of the university, or do we try to include it within our discussions regarding environmental law? I think some of you are already planning to have conversations regarding clinical approaches versus more holistic approaches, so I'll leave that for another day. There is, I think, a tension about the nature of compulsory versus elective. For a lot of students, there's very much a concern regarding status, that are they taking a course just simply because it's something to fill out their schedule, or are they taking a course because it's considered a very important topic by the law school and has given some degree of stature in terms of what students should learn. There are other issues, and I raise these because I know universities are different, and I know law schools are different, and this is something that will affect a lot of decision-making for many of you, which is the context of your individual campus. Environmental law, no one person can be an expert across all areas of environmental law. Just like no one person can be an expert across issues of economics, politics, ethics, law that may be relevant to teaching topics about the environment. And so the question is then, do we have the resources available at our university? Do we have the faculty available in our law schools to cover all of these different challenges or these complexities? Does the university allow us to draw upon these other resources? Does the university allow us the freedom and the flexibility to fill in the things that we think are important for environmental law? And of course, there's the expectations about what we think constitutes an environmental law education. Angelo, next slide, if that's possible. Okay, so the next thing here, and I think many of you alluded to this morning, but what I'm doing here is dividing things out to help organize discussion. There's a lot of, I think already today, there has been a lot of contributions from different people regarding the issue of content and the kinds of content that we want to include in environmental law course. I'm not going to read out everything here. What I'm trying to point out is that there is a way to frame these debates over content to help clarify our disagreements and our areas of agreement. And what you notice at the top there is 6 different categories. There's the general topics that we want to try and include in an environmental law course or environmental law curriculum. The question is, do we fit it within one semester, or do we fit it within 1 year, or do we try and distribute it across all the years of the law school program? There's also the question of approach. So I use the term epistemology, but some people use the term knowledge system, that issues of environmental, issues about the environment require some understanding or some discussion about things like science, economics, traditional knowledge of indigenous peoples. And this has all been highlighted as becoming increasingly relevant, particularly with international environmental law discussions happening at the United Nations, within the IUCN, and other institutions, where they recognize that environmental problems are multidisciplinary, interdisciplinary, and there has to be a way for different disciplines to talk to each other, right? That lawyers have to be able to talk to scientists, have to be able to talk to economists, have to be able to talk to political leaders. And so the question is, how do you engage in those conversations, and what kind of knowledge do you need to facilitate those conversations? So for us, those of us who are teaching environmental law, then, how far do we go in terms of introducing students to these other knowledge systems? And if we don't have the expertise to teach that, then where do we go to find that expertise? The other question, and I think some comments today already raised this, is, what institutions do we want to focus on? Do we want students to think about domestic courts, international courts? Do we want students to think about advisory bodies, the parliament, executive offices? So what are the institutions we want them to consider and think about when they hear or consider environmental law education? Some of you had already talked about, what kinds of statutes or regulations, so what kinds of laws do we want them to remember? There was one very good comment that had said, that students can now simply look things up on the internet. But for students to find things on the internet, or students to Google something, they have to know what search terms to put into Google, right? They actually already need to have some base of knowledge, so they understand where to look and what they should be looking for. So the question then is, what is the framework of legal sources that we want them to understand to help them guide their searches for legal materials? If we're talking about the sources for legal materials, then it also extends to sources for case law and case decisions. And there, I think, again, some people today have had made comments about there were cases in Philippines law, but there's also useful cases that are coming from other countries that can provide a lot of insights to guide judges in the Philippines now. So in particular, last year and this year, there were some landmark cases that came out of Latin America and South America and Ecuador, particularly regarding the rights of nature, the rights of indigenous peoples towards nature. And they're becoming increasingly cited just within the short time that the judgments have been issued. So the question is, how much space do we want to allow for these comparative discussions with cases or on emerging principles of environmental law from other countries or from international courts? And then the last category is just there were some comments earlier today about trying to have students go beyond learning doctrinal perspectives of law. So in other words, to go beyond citations of regulations or citations of cases. And there was one very specific comment, I think, about we want students to be able to reflect and consider on the expertise of other scholars. So, we want them to be able to read scholarship that has done research about environmental issues, particularly things that are relevant for deliberations of environmental law. But in which case, how do we find them? How do we choose them? What are the ones that are important? And can we make a decision about, how much we want to include in terms of the scholarship? So these are the 6 different categories that I think can sort of help to organize some of the viewpoints that people have expressed, and that viewpoints that people probably will express going forward after today. The last slide, Angelo, is the next slide. And so this is where we get to a lot of the conversation that Amanda has led regarding pedagogy, but I won't repeat everything or anything that Amanda has said. She did a very good job. But what I'm just simply doing here is, again, presenting a framework to help organize the points of disagreement and the points of agreement between everyone. And that I think a lot of the comments that people have made can be placed into one of 5 different categories. So, we talked about, how do we teach topics? And so I think there was a very lively discussion about the Socratic method versus other activities like experiential learning. So this is internships, clinics, that kind of thing, lecture, moot court, activity-based learning, these kinds of things. There's another point that I want to raise, though, and this, I think this was alluded to earlier today, but I think it's something to sort of think about, is the disagreements and agreements over the question of technology. And by technology, I mean, beyond just simply synchronous or asynchronous learning, or beyond, use of Google or electronic databases. But actually, it's on a larger scale. Like, what kinds of technology skills do we want students to have after they graduate, right? So, how familiar do we want them to become regarding forms of technology that go beyond the university, and the kinds of things that would be relevant for their professional careers going forward? I already mentioned the different knowledge systems, but again, different knowledge systems have different ways of instruction and teaching. So science has its own way of instruction. Traditional knowledge or indigenous knowledge has its own way of instruction. And so there's a question there as to how far do we go in terms of introducing those respective pedagogies. There's a question of skills. So beyond legal skills, there's also professional skills about, what kind of skills do we want students to have to just function, not just as lawyers, but also as professionals? The ability to present themselves, to communicate, to work in teams, to actually be able to lead teams. And then the last one, I think, is something that has not been addressed, but is the question of values. And if we're talking about environmental law, are we expecting students to take environmental law and seek private practice jobs with environmental law, or are we expecting them to do more careers related to public service and things related to advocacy and activism? In which case, that will orient a lot of the decision making that we want to set regarding curriculum. I'm going to stop the slideshow there. So, Angela, you can go ahead and exit out of the slideshow. And come out. And I'll just wrap up with a final comment about sort of the things that I've seen happening in other countries. With my colleagues in the United States, what's happening here in Australia, and the conversations I've had with colleagues in Thailand and Cambodia and Laos, that the meaning of legal education is changing. Things that I thought were standard in legal education are now being questioned. So, I was a product of a Socratic method, and I was a product of, very specific modes of analysis and conversation that focused on statutes, court decisions, those kinds of things. But within a lot of American law schools that I've spoken to recently, there's been open questioning about that, and open discussions about the need for law schools to evolve. Law schools have to change to changing circumstances. And in particular, the American Bar Association have speech from former Senator John Kerry, who said that all lawyers are now climate change lawyers, right? And the legal profession is now a climate change profession. And as a result, the standard methods of legal education have to be adjusted to accommodate for the priorities and the issues of climate change. And that means a departure from Socratic method to consider alternative forms and a changing in terms of the kinds of content that are included to try and allow students to be more flexible and more responsive to emerging issues regarding climate change. So I think that it's perfectly okay for everyone to try and allow for some experimentation, and the decisions do not have to be final, right? So that whatever decisions are made now or in the near future, that they're open for iteration and that we can continue to evolve as we go forward. So I'll stop there. Thanks.
Thank you, Professor Jonathan. Can we call now on Matthew?
Thank you, and I'm always happy to be introduced as professor. Sometimes I'm awarded an honorary doctorate. My supervisors in my doctorate wish that I had been more diligent, but I hopefully next year may actually get to that elevated stature of having a doctorate. But I have done this a few times, so thank you very much. And as Professor Jonathan says, the background for his talk was the idea of developing a model environmental law curriculum. And we've had lots of discussions over the years, and I've been doing environmental law since 1987. Indeed, when you talk about the experiential method of teaching, I actually had to request my then dean, Professor James Crawford, the late Professor James Crawford, who ended up on the International Court of Justice. I had to request permission to do a fifth-year course in my fourth year. And when he asked why I wanted to do planning and environmental law at the University of Sydney in my fourth year, I said, well, I've just been elected to local council and I really have no idea what I'm doing. So it might be worthwhile me understanding what the local planning laws were all about, which caused enormous grief to most of the professional staff and my fellow councillors, because I would come back from my lectures and say, well, actually, we don't have the power to do that, or we have the power to do that, or there was a judgment about this and the role of local government. So I found that the most valuable means, because I knew while going through law school just how powerful law was. If you understood the law, you could actually achieve significant change. And certainly as an environmental lawyer, that's where I've sort of ended up. So one of the things that we've looked at over the last year is the development of this model environmental law curriculum. And as Professor Jonathan has mentioned, this is quite an undertaking when we're thinking about focusing on ASEAN, but also then trying to identify national modules and national laws. And there is a lot of law, there is a lot of jurisdiction, there are a lot of cases and a lot of materials. But one of the things we wanted to do is try and develop this curriculum so that it became a living document that could be uploaded and contributed to by academics in the region. The other thing was, as has been mentioned, that there's so much more to tell, so many more subjects to talk about. Sometimes academics can teach an entire semester on climate change law and litigation. Other times they have to do the entire gamut of environmental law in one semester in 2 units. We talk about, I think Lisa was saying that at the University of Cebu, they have 5 units to teach environment and natural resources law, which is obviously double the time, but there's still so much to do. So what we've developed is this idea of this model environmental law curriculum. I should say that one of the things that inspired me was the idea, was something that the Asian Development Bank did in 1997, as mentioned by the General Counsel today. ADB brought together in Singapore and then later in the Philippines, but they brought together in Singapore some of the world's best practitioners on environmental law. And they put them together and they developed 2 volumes of environmental law principles and practice. When I first started working with the ADB about 12 years ago, I discovered this book, which was only available either in 2 huge published volumes or on CD-ROM. I don't know if anyone remembers CD-ROMs. They're now past technology. But this was a great
sort of tome of environmental laws, the best scholars that brought together. It also led to the formation of the Asia Pacific Center for Environmental Law in Singapore, one of the preeminent centers in the region for Asia Pacific environmental law. But one thing it did do is it was static. And as I think Jonathan has mentioned, environmental law certainly isn't static. It changes regularly, perhaps more than other areas of law. But as I think one of the comments was, teaching environmental law as part of business seems now fairly standard, because that's what we have to do. We have to reach out to the corporate lawyers to talk about various environmental law aspects. I'm always surprised that investment lawyers, when I talk to them about EIA, they sort of don't quite understand what that means. And I'm saying, look, this isn't some sort of voluntary compliance mechanism. This is a legal obligation for your clients. Climate change is not something that's going to affect them in 20 years. It's affecting them now. If you're advising on projects and investments, you have to take this into consideration. So one of the ideas behind this sort of curriculum that we've developed in a draft form is to ensure that it is a living document and able to be used by lecturers for either their own courses or developing a curriculum, but it is very much not something that is there for students. It's very much there for the environmental law professionals, hopefully in a broader context, to be able to pick out these modules and use them to support their courses. So we have developed about 30 different topics, and I'm going to take you through them now very briefly, and then provide you with the link and the homework for tomorrow, because tomorrow we will be spending some time looking at one particular subject and requesting you to identify cases, materials, legislations, like our first group today. I was copying that slide down. We can use that very much for tomorrow to bring that into this model environmental law curriculum. So, and at the moment it's set up on a Google document, which is now available, and I'll send out the link. So it's available for people to see and comment on. Within the context of this curriculum, and we have established, the ADB established a regional task force with members from the Mekong countries and the Philippines, as well as some international experts, including Professor Jonathan. We developed three essential themes. The first was an international theme. And so we have these 9 modules for environmental law. Again, the question is, if we need more modules, if we need certain elements introduced, this is all open and possible to incorporate. And what we've done is we've developed these broad nine modules as overviews for environmental law. At the same time, we've also then developed in the theme 2, the ASEAN environmental law modules. And these are trying to identify something that Professor Koking Leng from National University of Singapore has been working on, the idea that there is some form of ASEAN environmental law. These are sort of regional issues that are being developed over the years. So we've identified 9 elements, one being an ASEAN outline and structure, looking at ASEAN environmental and natural resource agreements, and some of the key issues: transboundary haze, plastics, biodiversity protection, transboundary river governance, which is in particular for the Mekong countries, EIA in ASEAN, and climate change in ASEAN. The third theme is what we call our national environment natural resources law. And this is something that we will be looking at tomorrow to get your input. We already have a lot of materials from last year's session, and some of the presentations there can form a huge foundation for the work on this particular model. And the idea is we then have some various particular topics, again, structured in a way that may not, everyone may not agree, and we're very important to get feedback and comment on how we structure these. Significant issues such as the sources of environmental and natural resources law in terms of constitutional law, access to justice, and under that we've looked at the role of the courts, dispute resolution, overarching procedures, and indeed protecting environment, human rights defenders, and SLAP suits and anti-SLAP measures. Then we have environmental impact assessment as a particular issue, because that seems to be one that's very important and relevant in terms of practicing and learning, environmental crime and compliance, and then certain sectoral issues, climate change, pollution, biodiversity, forestry, fisheries, and Indigenous peoples, energy, land use, mining and resources. Some of these are likely to be more popular, some of these are likely to be more used, and some of these are likely to be more developed. And so part of this process, not only in the Philippines, but in our other countries, is to develop materials that can be used by the academics and by the teachers to then be able to incorporate them within their teaching and within their curriculum. So within this sort of Google Drive, there are a series of resources, as well as within the themes, there are a number of particular modules. So I'm just going to take you through two quick sort of views from the theme one, which is the international theme. So for example, here you would go online and then you would click the module, and here we see the module Principles of Environmental Law. And we would click this. This brings up a sort of an introductory approach to environmental law, where we can see we have certain principles. We have an objective and introduction, the idea being, what's this module about? We can either identify key readings and key issues. In terms of the principles in this particular respect, it links in to the ADB eLearn, which has a series of 10 lectures that were modules that were developed by Professor Amanda on environmental law principles. That's a 10-hour course. It's very in-depth. Usually we wouldn't teach principles of environmental law for 10 hours, but certainly we can use that to develop the specific course material for this particular module. Again, within this sort of particular PowerPoint presentation, we've identified sort of key principles. And then there are particular references and further materials that can be used and identify, including references to other outside sources, such as the UN Infomea. And Infomea is the UN database that contains a wide range of teaching modules for a wide range of subjects, all of which can be used as an adjunct to teacher. And again, one links in, it redirects. You can then go on and see what it is that is available on the Infomea platform. I'm thinking if it redirects quickly, otherwise I may move on. And that would be, site can't reach. So that Infomea, you log on, you have your own account, and then you're able to identify a number of courses. And it's interesting that Infomea has courses on EIA, international law, climate change law, various protocols, or Basel Convention, for example. And I know some academics, some teachers actually use that as a teaching suggestion for their students, so that if there is a student who's particularly interested in waste, they can go on to that Infomea course, they can follow the course, and there's an assessment there. And the completion of that course is also then presented to the professor. So that's also one way of using some of these outside materials. Just because I'm passionate about environmental impact assessment, I wanted just to show you also, for example, in this module on ASEAN, when you see environmental impact assessment in ASEAN, you click on that, it brings up the objective and introduction. What is this course about? What is it looking at? It then has links. And so these links go to particular reports that are also online and accessible. And we may have, so this is a technical report on strengthening environment impact assessment procedures in ASEAN that was developed for UN ESCAP and UN Environment Program last year. The aim of this sort of online repository is that we can link to other materials that have been developed. There's also, for example, a link in terms of public participation to a project that I was involved in a number of years ago on guidelines to public participation in the environment impact assessment process in the Mekong And that has a lot about public participation. You can then click to download that particular report. In addition, we have, for example, links to presentations that have already been given under ADB projects. The idea of bringing together all of these resources, some of the webinars that we do, and materials that we've done. And then this would have a PowerPoint presentation on environmental impact assessment in ASEAN, happened to be done by me. It relates to sort of objectives, and this is then available for professors. Hopefully, we hope with all of these things that the professors and academics will be able to provide appropriate accreditation. But the idea is we bring together, for example, those particular documents and materials, and this was for another report or another webinar that was done by EIA. And then what we can do in these particular modules, we can add the issues that Professor Jonathan has identified, you know, the topics, relevant laws and materials. So for example, this is an article by Professor Taiming Yang, looking at the emergence of environmental impact assessment as a global legal norm and general principle of law. So every year we would be able to update this so that good articles, good webinars, good teaching aids can all be put on this particular Google Drive. What we've now done within the context of today is we've now shared the link to the Google Drive to all our online participants, and everyone in person will be sharing them to. And we will ask you tonight for tomorrow to pick one of those topics under your national environmental law, and tomorrow we'll work in groups to identify cases, materials, articles that we can then fill out and flesh out. Thank you very much. I'm sorry I've gone a bit over time. I'm very passionate about this, and I hope that this can be a living resource. I should also point out one of the things we're also hoping to do, we work very closely with the IUCN Academy of Environmental Law and the professionals in the Commission on Environmental Law to make sure that this is relevant. Within the context of the national law, the other, and I guess this is a sort of a passion for me, is the idea is that we will develop these national references, but in a comparative approach, so that you will see different countries, so that even if you're teaching EIA law in the Philippines, you can have a look and see what's happening in the region, what's happening in other countries, and see how that comparative approach can work out. So and things like wildlife crime. We've also included environment social governance law, because we see that as a new and emerging area. That's something that we hope can also link into some of these other particular modules, and that's how we can use the hyperlinks to turn them back into the climate change law. And we hope, and we're optimistic that that will be a living document that we can use going further into next year. And as the General Counsel announced, if the technical assistance program will continue, and one of the key elements that Christina Pack is very keen about is the promotion of this curriculum. We've called it a model curriculum, but really it is meant to be a living environmental law curriculum. So thank you very much indeed for your time. Thanks.
Thank you, Matthew. Thank you, Jonathan. We have 15 minutes for question and answer or comments. So we can ask our participants online and also here in the room for any comments, insights, questions. There are microphones on the table. Not seeing any hand raised. I know that's a lot of information. Yes, come.
Maybe I would just want to thank Matthew for that, because that would really help I believe our environmental law faculty. Like, the resources are all there, and you help us instead of us doing so much research, because you know in the country most of the law faculty members are really also have an 8-to-5 job. No, so what you have done will really help us teach environmental law better and to be kept updated. So from my end, I say thank you very much for that. And we are looking forward to the link.
Maraming salamat, as we call it. Okay. And yes, Professor Jonathan, any response?
I'll just make a note that so the materials that are on that Google Docs folder, I want to stress they're living. It's living documents. Yeah. So one of the challenges of environmental law is there are new developments every year. There are new environmental problems every year, and also that a lot of the legal concepts and principles and a lot of the legal approaches are changing every year. And so as a result of that, all the materials are meant to be iterative and open source so that if any of you feel that you have information that is more recent and more up to date, you are more than welcome to make those changes and to add in things that you think are more timely, and that will help all of us as a profession, right? The larger goal is to promote environmental law the larger goal is promote environmental law expertise, not just for law schools and students, but also for all of us as environmental law professionals across the Southeast Asia region. So it's a collective project and it's ongoing. So thanks.
Okay, thank you. Any more comments? Yes, Dean.
Thank you very much. And also, I am very inspired, especially when you mentioned about the living curriculum. And of course, we have to thank the LEB being here, because while lecturing earlier, I was so inspired that I have to write on my own reflections, actually a curriculum for the Master of Laws program on environmental law for San Sebastian College, Recoletos, Manila, because that's one proposal. Because earlier I was speaking with DNR here representatives, and we are already we're already making something for the Master of Laws for the environmental law. And of course, we have the LEB here, and with the support of everyone here, we can make collaborations and make extra effort for this program. And I think that's one thing that is necessary for this country, because there are students for the Master of Laws program, one of our graduates is attorney Rose Lisa Osorio. We're very proud. And I think for the Master of Laws program, because we are teaching teachers mostly in the Philippines, I think this is very important. And with the help and assistance of the Legal Education Board, we can truly implement this. And for the modern, living, and impactful curriculum, we'll do this. Thank you.
Thank you, Dean. Any more insights, comments, or questions? Yes. Yes, sir.
Is actually directed to Commissioner Jojo and to the Legal Education Board. The question is, are we limited to the description in the curriculum regarding what we should include in our environmental law teaching?
No, you are not limited, sir. In fact, our revised model law curriculum is just a guide for all of us, because as we know, in Pimentel versus Legal Education Board, the Supreme Court really emphasized academic freedom. And in the design of your curriculum, law schools have the academic freedom. All you have to do is just to inform us of the new course description, so that we could also have that as a public document. That's what we really need for you. So you have to submit to us the course description as well as the syllabus of your, if you have something that is, you are already creating a new course description, or you are enhancing the course description in the model curriculum, then what is needed is just to submit to the Legal Education Board the course description as well as your syllabus. And you have all the freedom to be creative in delivering environmental law, delivering knowledge in environmental law to students.
Yeah, I have just a comment. It's just a 2-unit course in most law schools, and we cannot cover so much. Even the rules of environmental procedure will take at least around 6 hours to teach. So that really restricts the ability of a professor to cover that much. I think having taught 2 units and 3 units, 3 units is good. But 2 units, it's just restricted.
Yeah. Sir, again, the model law curriculum has lowered down. It's really minimum. Your RMLC is minimum. You can really expand it. That's why in the past, we have, I think, for Bachelor of Laws, we had 150 plus units. That was really required. So we trim it down to 130, I think. I cannot remember anymore that. We trimmed it down because we know that we must give law school the free hand to determine what is in their context, what is more needed. Like, for example, if we're saying 2 units is minimum for all, you must have at least 2 units environmental law because that's mandatory. But if your law school sees as part of its vision to have really a more comprehensive study of environmental law, you are given that free hand. Kasi tinanggal na nga yung 30 plus units na mandatory noon. Kasi noon 150 mandatory 150. Sinabi ito dapat. Ngayon, we freed that up. 130 plus na lang yung ito dapat. So you already have enough elbow room if you want to add to that 2 units. Ito lang is we're saying everybody must teach environmental law for at least 2 units. So you have that elbow room. In fact, if you look at the curriculum, yung model, when you go to 3rd year, yung second sem yan, wala na yan. That's all electives. Like it's all your free hand. But of course, you are also given the freedom to determine on the sequencing. Diba? Hindi naman kayo sinabi na dapat dito talaga yan ituro. Okay? Your revised model of curriculum is really a guide. A guide for law school na at least ito dapat nandyan. Okay?
Thank you,
So,
Conjo.
Professor Galahad, yes. Yeah.
Yes.
Briefly, I brought with me the the resolutions and administrative orders of LEB. Dito sa bagong model curriculum natin, there are 2 subjects on environmental law. One is environmental law, 2 units, and the other one is environmental regulations. The procedure can take care of that. So, hatiin mo yan. Hindi lang 2 units, but 4 units, but 2 separate subjects. The first is on purely law, the other one is on procedures. Thank you.
Thank you, Com. In fact, if I may share, Matthew, I was telling Matthew in the Palawan City University, 2 units of natural resources and 3 units of environmental law. That's why we can really afford field trips. So that's an advantage. Yes. Any more comments from the online participants? Yes. Ma'am Michelle.
Good afternoon po. Reaction lang and comment. I think I have experienced the evolution of environmental and natural resources law. When I started teaching in one law school here in Cagayan de Oro, the subject was natural resources. It was 2 units. And then in the other republic, in the other law school, it was an elective. Environmental law was an elective 1 unit. And the other 2-unit subject of natural resources in the 2nd semester. So the elective was offered in the 1st semester and the 2nd semester natural resources law in the other law school. So I had difficulty formulating my course outline because the first problem of a teacher, of a professor, is to make the outline. So I would want to incorporate environmental law in my natural resources law in one law school because it didn't have environmental law. The other law school has a 1 unit. So I made my outline in such a way that it incorporated both environmental laws and natural resources laws. So my outline was, the outline I prepared was actually approximating that of Professor Matthew. Although yung kay Professor Matthew, if we compare it to a piano piece, yung kay Professor Matthew was the advanced, difficult music sheet. Mine was the easy version. So I discussed the outline. The first part of the outline, which is letter A, is introduction to environmental law. It included environmental justice, principles of the right of the environment, the stakeholders, etc., the local government units on the environment. And then the laws discussed there, the laws included are EISS, the Environmental Impact Assessment, Clean Air, Clean Water, Solid Waste Management, Toxic Substances, Biofuels Act, there. I had difficulty categorizing the environmental laws. We all know that there are two categorization or classification of our environmental laws and natural resources. One is according to the color-coded categorization, the blue, the green, and the brown. And then the other one is EDU, exploitation, utilization, protection, and then the third one is pollution and environmental management. So I decided to make it simple such that environmental laws and environmental regulation are taken up before the midterms. And then after the midterms, it would be natural resources law. So PD 705, small scale mining, Philippine Mining Act, Public Land Act, IPRA, the natural resources laws. So the rules of procedure for environmental cases, I included that. The first part, the civil procedure, I included that in the environmental laws discussion. So the civil procedure. And then the second part, the criminal procedure after the midterms relating to the natural resources laws, because criminal procedure is related to natural resources. They are penal in nature. So ganun po, it's really the subject is very broad.
Okay.
I think the three unit environmental law and natural resources would not even be enough, no? But ayun po, that's my experience, evolution of the subject. I am happy that it is now a 3-unit subject. In the recently revised, no, it was a 3-unit subject in both law schools here in Cagayan de Oro. So happy po kami. The only problem we had was it's in one law school, it's taught in the first semester, first year. So we had difficulty explaining to our students because it's the first time them meeting Declaration of Principles, constitutional law one pa sila, and then they will be introduced to the right to read them in harmony with nature. So we had difficulty explaining to our students because they still do not have a background in constitutional law. But now that it is offered in the 3rd year, and well, I think tamang-tama na po. I think medyo okay na po.
Thank you, Attorney Michelle, for sharing. Can we will, yeah, we're on time. It's 3:00. Can we give ourselves another 3 big claps? Thank you. So we'll have a break, a health break of 15 minutes, right? 3:00 to 3:15. And then we will proceed to the next session. Thank you. Thank you. Thank you very much.
In the Philippines, a longtime environmental champion, Professor Jerty Mayo Anda, has been working tirelessly for decades to defend the people and environment of Palawan. In 1990, Jerty founded the Environmental Legal Assistance Center, now one of the Philippines' most active NGOs that helps communities uphold their constitutional rights to a healthy environment.
Sound. Sound.
Can we ask our law professors to come in so we can start? Good afternoon, everyone. We're calling all our law professors. Our professors online ready? Okay, so Professor Amanda and myself will be handling this last session for the day. And this talks about updates on pedagogy and teaching approaches. So, Angelo, can we request our slide? Okay, here it comes. So, this morning and until early this afternoon, we have heard a lot of the creative and also passionate sharing and insights from our law professors. So this is intended to add or to emphasize certain things that will enliven and be more engaging as we teach environmental law. I've identified 4, but actually there are more. So for student internship programs, can I go to the next slide? Next slide, please. Okay, so I identified 4 possible activities which we are doing already. We've been doing for years. And I'd like to start with student internship programs. Next slide, please. The student internship program, a non-government organization, the law school actually links up with government agencies or civil society groups to bring their summer law interns or semestral break interns to work as a law intern with a non-government organization or a government office. And I have had the privilege to have one of the law professors here as my intern. Can you stand, Angelo? Attorney Angelo, can you give a clap to him? He's from the University of Zamboanga. I'm so happy to see you after all these years. So he was an intern of our organization, Environmental Legal Assistance Center, in 2013. And he traveled all the way to Southern Palawan to look into the experiences of the Fishers indigenous peoples battling with a proposed coal project and also mining. So essentially, through an internship program, there can be practical experiences that the students can work on real life cases, because when we see the curriculum and we see the laws, we know that they're all rhetoric. And the challenge, therefore, is how do you make them a reality on the ground? And then the students see the gap and the distinctive challenges for every type of law or type of regulation or program. And in the process, they can also develop the ethical skills and also incisiveness to see that if, let's say, the government, for instance, promotes coal in its Philippine energy plan, then students might try to ask why this is so, considering that we are signatory to the Paris Agreement, and there's nationally determined contributions by the Philippines. So those are questions they raised. And therefore, whatever they do can contribute to an advocacy agenda, sustainable development agenda within a political or even national context. Next slide, please. So in a student internship program, like what Angelo underwent, it's a minimum of a month to 2 months. And depending on the cases, like these are photos of Attorney Lisa's group in Cebu, the Philippine Earth Justice. The interns there prepared sworn statements of the witnesses in a case, or they are required to write letters or submit position papers on legal policy issues, or they can draft written arguments. So for instance, in my experience, we had several law interns helping us in developing the position and also the case to assail the proposed 3-in-1 Palawan law. And I think you've heard that we won recently last year in the plebiscite. So the law interns did a lot of research. They looked into the environmental arguments, and it was very inspiring that they were part of that, and they all celebrated when we won the plebiscite. They can also represent clients in public hearings, and then some of them have translated, this was years ago, they translated specific laws into Tagalog or Bisaya, like in the case of Lisa's group, and they participate in field investigations. So when they do this, participate in public hearings, in the case of Angelo, he even joined a Palawan Electric Cooperative Assembly. So he saw the overlapping concerns between an electric cooperative, a local government unit, the Department of Energy, and the Department of Environment and Natural Resources. So overlapping institutional roles, okay, and the issues that actually come in between are actually understood and appreciated, because you do not see that in the law itself. So that's a real life. And then in our case, because a certain school like the Ateneo Law School or University of the Philippines, I was talking to the dean of San Sebastian and also San Beda that, perhaps they can also send interns. Actually, LaSalle also sent interns to other schools. So they work during that period of time, a minimum of 3 weeks to 2 months, and then they get the chance to work with other NGOs. Next slide, please. So these are the activities I mentioned. And it's also good to underscore that many of them have become public interest lawyers. Like, I think the Filipino Justice has about a few lawyers working with them. And also we've had also lawyers working in other parts of Luzon and Visayas, Mindanao, and Palawan. So that's good. The outcomes, actually, they contribute to the current agenda of becoming part of the problem, pushing for better laws, and ensuring effective enforcement of these laws. Next slide. And there's a lot of preparatory work though. Next slide, please. When we actually plan this internship programs, there are costs involved, and there are also warm bodies that need to be mobilized. So therefore, when the law interns go to an area, like in the case of Angelo, the travel and the food and everything was covered. So that is also something that the law school and the supervising NGO or the civil society group will have to agree on. And then all the interns undergo a basic orientation seminar. That means it's just like familiarizing themselves with human rights laws, constitution, and all other laws that would be useful in being able to address needs of poor and marginalized communities. And then there's an evaluation. So we do post-internship evaluation sessions. That is very important so that the interns give feedback on what they learned, and also the law school and the civil society or NGO group. Funding is a key concern because during COVID, we've noticed that the funding has decreased. So we did not get an intern this year, but despite COVID, we had virtual interns. So we had virtual interns, and of course it was limited in terms of research. They missed the travels and the field investigations. But even then, they participated in crafting letters, petitions, and doing legal research. There was an experience as well, a virtual law intern helping craft a judicial affidavit for a specific environmental case. So that's for student internships. For student-led seminars, and this is one of the things, this is a favorite because students are assigned to really read on the laws, cases, jurisprudence, and even case studies related to the law. And then they present it in PowerPoint, and there's a discussion in class. So they are there prepared, and therefore there can be a a sort of exchange of ideas. I mentioned about issues that they can disagree on, But as we said, they can have class discussions even during the seminars. I also like to include here role plays. Role plays I thought were only face-to-face. But recently, early this year and last year, I had virtual role plays. So it was possible before the Pollution Adjudication Board on a pollution case or a forestry case. So that actually not only enlivens the atmosphere, but also make sure that the students read the law and are compelled to write a doc or prepare a document and then prepare for that proceeding. Now, moots. Lisa is an expert on moot and also Amanda. My experience in moot last year and the other year was in connection with the law dividing Palawan, where we had students being questioned, okay, both sides, they prepared a memorandum, and therefore there's a bench, okay, there's a panel of experts who will throw questions to them. This is a great example of a student-centered learning because they prepare, they study, they understand the law. The nuances involved in a particular policy are very, very important because you do not see that in reality. So when they get hold of these cases, plus they do exchanges with other students and possibly even other law schools, that would be wonderful. At this point, I would like to turn over to Amanda to talk about, next slide, please. Okay, let's finish student-led seminars and then next slide, please. Okay.
So I think Jyoti has already touched on moots, which some of you may have already had experience with, particularly in the face-to-face setting. And, you know, as Jyoti has just said, it's very much a student-led approach. They assume the role of the advocate. They will argue points of law before a bench, which can either be made up of perhaps visiting professionals or staff, or even some of the students can take on the role of the bench as well. And it really does teach those courtroom formalities and procedures. So to the extent that we might be wanting to instill those professional skills in students, you know, it can really replicate that court experience. But we do know that they involve a significant degree of administrative coordination, and many of you will be familiar with that. If we can just move to the next slide though, what I wanted to show you, given that Jyoti has definitely touched on some of the face-to-face experience, and Angelo, if you could just play the video that's on that slide for me. I just want to show you a virtual moot and the fact that we do have the technology available to set up a virtual courtroom, and in a moment you'll see the avatars of the students that appear there, which basically is a short way of displaying their video screen, and then it pans to them and they will speak and deliver their submissions or perhaps present evidence, whatever it might be. So we do have the ability to have these platforms, and there's the little video avatars, so they're physically located in the virtual courtroom, that enable us to replicate to some extent the in-courtroom experience. So the technology is there to do that. There are obviously, you know, a need for very clear protocols around how it's going to work, because obviously we don't have any of the nuances around body language and that physical interaction that you would have in a courtroom setting, in a physical courtroom setting. So you will have a copy of the slides, and there is a link there to get more information on one institution's experiences with the IC platform. On a much more scaled back level, you can also use Zoom to run moots, and I have seen Zoom used to run virtual moots as well. You just don't have the nice little avatars and the courtroom setting around you, but there is that possibility too. Now, students have reported both positive and negative experiences with respect to virtual mooting compared to face-to-face mooting. On the one hand, they said it really was absent that immediate sense of being in a courtroom with a judge. So it did lack that level of formality. And as one student, to use their words, they said virtual mooting isn't a substitute for advocacy training in person. Standing physically before a judge or arbiter adds the theatrical element that tests the student's abilities that might not be present in a virtual moot. However, another student then went on to say in research that was looking at these experiments, say that they found sitting in front of a screen no less nerve-wracking than they would do being in a real courtroom. And they said that on one hand, that you had the sense of being closer to the bench than you would be in real life. All of the participants in the research commented on the need to operate technology in addition to presenting arguments, which added a layer of organisation and perhaps a layer of anxiety as well, that they needed to be very well prepared. But it wasn't felt that it was a serious barrier to conducting the moot. Now, some of the positive reflections of students, and I think this is where it's quite interesting, is that the virtual moot setting gave them an opportunity to practice courtroom procedure without the need to be in the physical courtroom. So if they weren't able to access a physical courtroom, this gave them the opportunity to have a practice in a quasi-court setting. And the potential for international mooting, where there was no need to then engage in extensive and expensive travel, meant that students could really just focus on their preparation and their speaking and not worry about the stress of traveling to attend an international moot and that sort of thing. Students who did the virtual mooting also commented that they could concentrate a lot more on their speaking and their vocal delivery than they would do in real life, particularly because they were getting that instant video feedback. They could see themselves and how they were coming across. So one student described this as having the ability to slow down their delivery, to use more pauses and really concentrate on their verbal cues. And another student reflected that it seemed less formal and less daunting than a real life moot. So, without wanting to be cliched, I think the jury is still out on virtual moots. It's very experimental still. It is in early phases, and there is a bit of expense involved in certainly some of the higher end platforms like this that are used. But to the extent that you think a moot is a valuable learning experience or an appropriate learning experience, the technology exists to run such an activity virtually in the event that you're not able to do it in a face-to-face environment. Could we move to the next slide, please, Angelo? So I wanted to touch very quickly on field trips. And I know, again, this is something that is quite popular here in the Philippines. And Jyoti, I believe this is a picture from one of your field trips, correct? This is something that has long been recognised as one of the strengths of environmental law teaching. And I think more so than probably any other substantive area of law, environmental law just offers that really powerful ability to take students to locations, to see environmental law in action. And I know myself, we've been able to take our environmental law students to the courtroom to hear cases being determined and to the sites of environmental disputes or disasters or other activities. So it really is recognised as one of the strongest teaching methodologies in environmental law because it has that ability to really bring the law to life for the students so they can see how the law plays out in reality. Now, of course, field trips involve a number of considerations around the time that is involved, the cost, and whether or not there are other restrictions on travel. And so I think what I wanted to put forward to you today is, on the one hand, we definitely have the ability to run field trips, and it looks like now that we're slowly returning back to normal, field trips are back on the agenda as a valuable and viable tool for academics to use. Can we just move to the next slide, please? But what I wanted to, I guess, put to you is that where it is not possible to travel, for example, where there is a global pandemic that is restricting mobility and movement, or where there is a field trip to a location that is cost prohibitive or organisationally impossible because of perhaps student concerns, institutional concerns, whatever. I want you to understand that there is the possibility to run virtual field trips. It's not to say that they're better or worse than an in-person field trip. It's just another alternative. And so obviously when we went online in March 2020, our initial responses, particularly for those of us that were running field trips in our courses, was very reactive. Some people just cancelled face-to-face field trips. Or we went to looking to provide students with data and other video footage. And they started to become a little more sophisticated. We were able to create more virtual field trips. And I think, I guess one thing to be aware of is that there are actually benefits to creating a virtual field trip. And when you can combine a virtual field trip with an in-person field trip, we start to get into the realm of really engaging multiple channels of learning for our students. So I think one thing to be aware of there is that a virtual field trip can augment a face-to-face field trip, or it can be a standalone experience if needs be. If we are very mindful about the platforms that we use to deliver virtual field trips, students can access them through handheld devices, and they can come back and revisit the information, which is not something they could necessarily do on a face-to-face field trip. We know that virtual field trips are a more inclusive learning experience. So for students who perhaps have a disability or who are unwell or unable to travel, they are still able to participate if we use a virtual option. And you don't need to use high-tech platforms. So be aware that sites like Google Earth and other drone footage and other videos are all freely available on YouTube. The difficult thing is spending the time curating all of those resources and bringing them together in a way that's easy for students to navigate. So if we could just skip to the next slide, Angelo, and the next 3 slides are just some videos to show you some different, sorry, you'll just need to go back a slide, Angelo, and play the video. So this is a virtual field trip that was set up using Google Maps. Hopefully it works. And so you can see when you use, oh, it's disappeared again. Sorry, Angelo, would you mind going back? Technology, it's wonderful when it works. So hopefully when the video starts, this will show you a virtual field trip, which took students using a Google map view to see the site of a dam that was being proposed. Now, I must admit that this involved some significant additional work on the part of the educator to map out and include labels of sites that were relevant around the construction of the dam. But you can see that it's possible. If you can't physically take the students there, you are still able to take them through some of the key physical components. And what I love about this is a dam that's in the United States. I can't take my students there, but I can easily show them this resource. So that's one example that you can use. You can go through to the next slide. Thanks, Angelo. And sorry, one back. This is some time-lapse footage of that I've actually used in my own teaching of some coal mines, and it shows students from the 1980s through to present day, the impact. So Angelo, if you could play that video. There we go. And so if you just look in the middle there, you'll start to see, and it gives students an appreciation of land use change over time in a particular subject where we were looking at the expansion of coal mines in a particular area and the impacts on land use. So the time-lapse footage feature in Google Earth, again, is a fantastic feature that you can easily utilize to show land use change over time and give students a really tangible look. I mean, we wouldn't be able to appreciate that either by going to the site. So again, a great resource. And the next slide, thanks Angelo, and it is again another video. Now this is actually of that site that you just saw in the time-lapse footage. This is some drone footage taken to show the students. Now again, this is not a view that the students would be able to appreciate in person because you simply cannot get access. But using drone footage, we are able to get in there and really show the scale of the impact on the environment. So thanks, Angela. If you could go to the next slide. So I've included here some useful links that you might find helpful in your own practice. The Nature Conservancy and Discovery Education both have a great collection of virtual field trips, typically based in the United States, although Discovery Education has a few extra resources from around the world. Now, again, these are locations that are located generally outside of the Philippines, so they're unlikely to be spaces that you would be thinking about for a physical field trip anyway. But they really do show some incredible footage and bring home to students different cases that you can use in your teaching. Google Maps, Street View, and Google Earth Tour Guide. There are some examples at that final link there of field trips that you can create for students. And of course, you're able to create your own. So I would really encourage you, if you haven't used those tools and you're thinking about doing field trips, to go in and have a look at those tools and play around with them and see, because you can really create some powerful experiences for your students that don't really require them to go in person. Is there another slide, Angelo? I think that might be the last one. That's it.
Thank you, Amanda. We have time for, yes, questions. 30 minutes. Yes, Matthew?
So I can just comment that Professor Jonathan talked about the virtual experience idea seems like an opportunity for cross-disciplinary courses, maybe law and media and computer science and geography. And I would also say that, I mean, this is some of the things, if you did something in the Philippines for one of your courses, please upload it on the model curriculum so that people can also appreciate some of these really important visual tools. Thank you.
Questions or insights from our online participants? I see, I know that Norm is there and also Tony Mix. They've had interns as well. Or anyone from our room. Any comments, questions, insights? I know it's yeah, it's late. It's almost 4 o'clock, but it's about 5 more minutes. Yes, si Attorney Noel.
Isang magandang hapon at bumapayapang araw. I'm Noel Ben from the Notre Dame of Marbel University, Coronadal, South Cotabato. I'm very, very much, overwhelmed by this kind of transformative education. The model of the curriculum, very, very interesting. But, being hands-on, being on the ground, what I'm afraid of, that these are actually the things that we cannot make use of it when we are actually doing these things on the ground. That's one thing, because that's why these are all appealing to intellect, if I may. But, being a law clinic director of our Marisol Center for Justice and Good Governance, of which environment is actually our advocacy focus, among others. I used to pose this question to my students, not only what they have learned, but where is environment in the earth of our heart? And for that matter, posing that question, they are very much, aware where we are actually leading to, on how we will go with our law clinic. Because down there, I do not know if that partakes of the preserving of the nature, especially the wildlife, but there are so many sharks from all aspects, from different, and I'm afraid I have one particular experience, of, motivating, really forming this, nurturing that seed in the heart of every student to have this love for nature, put that, fertile their hearts of having this love for nature is, sharing with them some of my experiences on the ground. Like, for example, where are we in the midst of all these things when during at the height of the pandemic, there was a fisherman who was actually put into detention for cutting 2 mangrove trees.
And because of the pandemic, he was actually detained for a period of 3 months. But there came experience wherein more than half of a hectare of a mangrove having cut down. And yet the prosecutor, when we filed the case, didn't even find any probable cause. So I'm sorry, if actually I'm being containing myself. That's why I talked to Ma'am Jer and even to Ma'am Risa. I do not know if these are things that I misplaced, but being in the law education, I think it's just not more of, I do not know. I'm very sorry. I cannot control myself anymore. But just to share with you some of my sentiments. Some of my sentiments. It becomes rhetoric that we are stewards. But when we see evil before our own very eyes, how much had we done? How much had we done? And that's why this is actually my call to our law students. Our call really to our law students. Grade, fine. But when you are there doing all of these things, how can you translate into actions what you have learned is something, far more important. And we cannot check them. One intern, go back when I was actually with the U.S. Embassy program, the Access to Justice Advocacy, and I see Judge Jerly and Judge Te. We were with them. Actually, at the time, one intern was actually, had this immersion. And where is he now? Influencer. Even going to the office of the prosecutor or something that, I know this guy, and then, sad to note, he's a lawyer, actually, he's a lawyer. But where is he in all of these things? That's why I'm afraid that we have all of this, ideal curriculum, the model and everything. But how sure are we that by the time when they become a lawyer, or even not become a lawyer at the time, where will their hearts be in as much as environment? That's why I end my sharing also to that question, where is environment in the earth of our heart? Good afternoon. Professor Noel, do you want to respond? Attorney Noel, thank you for your insights. I would also invite some insights from fellow law professors, and I feel your frustration as well. But where does hope come from? Okay, there are also a lot of things that should make us hopeful, because there are cases won and there are protected areas that you and your team have continued to protect. So I know that the rhetoric versus reality is there, but let us also try to look into, I think the exchange would be among ourselves would be very important. The good practices, initiatives, success stories that should continue to give us hope. So I don't know if I can help in any way, but I also feel you, because you also have the same situation in some of our cases. But we had a TEPO recently, and the court extended it on a proposed reclamation project like you. So there is actually hope after all. But I respect and I understand, where you're coming from. So we should not also lose sight of your insights. Thank you. Thank you very much, Amanda.
I would just add to that. Is that working? Yes. I would just add to that. It's an area that's actually started to attract a little bit of attention in the research. And one of the chapters in our book is actually on this idea of engendering hope in our law students, in our environmental law students in particular, because when we're faced with ecological crisis, when we're faced with constant challenges, the ones that you have just mentioned yourself, it's tempting to give up, isn't it? And wonder, are we having any impact? And they really reframe that narrative to one of hope, and to saying, there is an importance in having these sorts of networks where we can come together, where we can share our collective frustrations, but also talk about our stories of success and where things are working. Believe me, I know that some of those examples I gave around some of the online field trips, it's never as powerful as being able to physically take our students to some of those sites and having them maybe hear from someone like the fisherman in person. But we can't give up hope, and we have to use all of the tools that we have available in our toolkits to try and reach those students and to, as you know, as you say, plant the seed in the first place. So if you contact me afterwards, I'll see if I can get a copy of that particular chapter for you around engendering hope, because it was a very interesting take on why we need to keep persisting and why, you know, why it is tempting to stray down that path of pessimism and thinking that we are banging our heads against the wall and not getting anywhere. But there is an importance in trying to engender hope. And yes, exposing our students to the realities of ecological harm and loss, but then showing them the stories of success and how incrementally we have been able to make a difference in different areas.
Thank you, Professor Amanda. Thank you, Attorney. From the online, please. Can we have, yes, Dean Mix. Hello, Dean Mix. Nice to see you
Attorney
online.
Jerty. Yes, yes. Thank you, Attorney Jerty. Can you hear me? Can you hear me, Attorney Jerty?
For you, Dean Mix.
Me, it's very difficult to really cover the entire field of environmental law. You have national laws, environmental laws. You have regional environmental laws. You have environmental conventions and treaties. So difficult to cover them, even with 3 units of environmental law. So what I do, I try to instill the environmental law, environmental conscience, and interest in students. So I teach them the basics like sustainable development, intergenerational equity, precautionary principles, etc. And then hoping that in their own time, and even when they become lawyers, they are able to just read the laws by themselves, you know? But with an environmental perspective, environmental conscience. And after that, what I do, I assign the students a specific law, for instance, fisheries. And I tell them to go to an area in the community. Most likely they will go to a coastal area. Then immerse themselves in the life and legal, social problems in that community. And they try to see if the fisheries laws, what areas the fisheries laws can present it in class. And I assign the rest of the students listening to do a critical analysis of the facts and the fisheries code, fisheries as presented. And you know what? The results have been very encouraging. Students, for example, came up with gaps of the law. For example, about SLAP. And in fact, she has now made it into her thesis material. Another came up with gaps in fisheries code vis-a-vis the NIPAS law. So you can see encouraging results, students becoming interested in this area. That's why I say it's very difficult to really focus on all the laws. My God, it's overwhelming. Overwhelming, just the international environmental laws. I don't think one could cover that very sufficient. So that's my experience, Attorney Jerty, and the rest.
Thank you very much, Dean Mix. He's from Silliman University, Dumaguete, professor of Attorney Lisa. Thank you for your insights and sharing your experience. Yes, Mads. Attorney Amado. Oops.
Yeah, good afternoon again. I just would like to share my experiments because I have experimented on the field trips, and I would like to assure my classmates in the online and here also, mga kasama namin, try field trips because it will become one of the most memorable days in their law school life. In fact, they even still call me and tell me about what they did because I made them plant trees. And those who were not inclined to do that jokingly tells me, you made me plant a tree. So they still tell me that. And some of them are creative. In one class, what I did was I asked them to choose whatever law they would like on environment and then to make a film about it with them as stars of the film. So, and we showed this in the classroom, and they became very, very creative. Some went on pollution, some reported on pollution, some reported on animals, forests. Ayan, mga yan. So, one time naman, it was we were not so successful because the bad weather overtook us. But you can see in the faces of the students how excited they are to go to these tree planting activities. You will be surprised. So I would like to encourage all of those present to try field trips. But of course, you will have to ask for a waiver because of the problems on damages. So that's why I asked Attorney Jerty earlier about it. So what should I do? She said, ask for a waiver, something like that, no? Because we know the jurisprudence on this. So thank you very much to
Thank
everyone.
you, Attorney Amado, Attorney Mads. Thank you. Yes, prosecutor.
This is just a reaction to the expressed frustration of our brother Professor Noel. On the part of the prosecution, rest assured, brother, we are doing all our best. That's why we are training our own fellow prosecutors so that those kind of fiasco will never happen. In fact, aside from developing a basic course on environmental law, we are now coming up with specialized courses. And hopefully with a partner, a developer, we can achieve that. Okay.
Thank you very much. Yes, Professor.
Yeah, with respect to the virtual moot, that takes a little kind of work. It takes time to do that. It takes technology. It takes practice, especially if the students are going to invite visitors and guests. That's going to take some work, but the added benefit to that is you are enhancing interaction among the students. So they get to work with each other, even though only virtually. So there is now some form of discussion, planning among them, and it enhances their learning, also with technology. And the other reaction that I'm going to make is, if there is hope, I always show to my students, I always assign to them the story of a civil action. I think Professor Purisima there knows that story. So you have here an environmental crusader, okay? He took along a water contamination case. It was tried, and during the trial, it was proven that there was wrongdoing on the part of the defendants. There was a judgment rendered by the lower court, and the lawyer went to the lower court judge, presented the wrongdoing. Lower court judge did not see any wrongdoing. So lawyer did was to go to the Court of Appeals. Court of Appeals said there was wrongdoing, but it threw back the case to the lower court judge. So the lower court judge rendered a decision, and the decision was again sustaining his decision, his wrong decision. And then it went again to the Supreme Court. Supreme Court saw the wrongdoing and yet did not do anything because of, I think, stare decisis. So in the end, the one professor who was involved in that case made a statement that when I was young, I always thought that judges would do something if they saw wrongdoing. I was wrong. So, you know, at the end of the story, and I always keep students thinking, and it really stimulates their passion for justice just by reading the story. Because it's a very nice story, not only from the environmental side, but also with respect to ethics. So that's a good one. And in the end, there was justice. Because while the lower court did not rule in the civil case for the plaintiffs, later on, the EPA would initiate criminal action. And they were held liable.
Thank you. Thank you.
Can
Yes,
I
Amanda.
just that I would add that
Attorney Jody, we have someone.
we have someone online. I just wanted to add, following from that, the comments there. We also have our champions videos. So it's probably a good point to plug those to mention that we have a series of videos that you can also use, which show stories of various environmental law champions as a source of inspiration and to show some of the gains that have been made, number one. And I just wanted to echo that point about the moots and the ability for virtual moots to introduce students to the technology. Something that we heard yesterday in our workshop with the LEB is that there are courts now moving online, moving increasingly online. So to a certain extent, virtual moots can also be a very realistic learning opportunity for students in the event that they find themselves needing to appear virtually in a real court. So it can be a source of helping students to get familiar with the technology that they may be using in practice. I think we have an online question. Remelisa.
Remelisa. Yes, Dean, Remelisa. Yes.
Yes, hello.
Dean Moraneda.
Hi, this is actually already my fourth in a series of attending the trainers training. No, if you remember, I think Attorney Gertie and Ma'am Lisa can remember one of the things that stayed with me since that session in Cebu was really the role playing strategy. If you remember, we had so much fun with the role playing, and then that is what I stuck with. No, so that's my instead of finals, I do role playing. But during the pandemic, it got expanded because I was so inspired by an LLM class I had at San Beda, where there was really a hypothetical case, and I think it was very relevant in our locality because we have a lake, and then it was I made a hypothetical case about a particular ordinance that the municipality would like to pass, freeing regulation on fish ponds on the lake. So I assigned actually parties to the case, including the indigenous people. So they had to research. I was so surprised. They did a lot of research. I was just thinking that they would do the pleading and submit the pleading. Oh, the pleading was very good. They did a lot of research, even taking some international quoting or citing some international cases in their pleadings, because I included even the market vendors, all the parties, all the stakeholders, the NGOs, the fish, the small fisher folk, and they really enjoyed it. So I think I think that is one thing that we can also adapt virtually, because I did that virtually through Zoom, because I chose that because most of my students are working students. No, about 98% of our student population are working. So they really do not have time to do other things like mooting, or I think role playing is also in a way a form of mooting, but they were able to do this by groups, and they were also able to do their research. Their pleadings is already their final paper by groups also. And I had very good reviews from my students after that because they enjoyed it very much. So thank you very much. That is
Thank
just
you,
my,
Dean Moraleda. Thank you. Anyone else online?
Judge Jurley was also.
Who else?
Judge Jurley.
Jurley requirement.
Yes,
Jurley, yes.
Yes, good afternoon.
Good afternoon,
I don't know if
Judge.
you can hear me. So I will comment first on the use of virtual platform. Actually, when I had the Leadership Development Program Fellowship, at the height of the pandemic, our modules immediately shifted to virtual. And I had that first virtual experience of Mount Vernon, where George Washington resided. And it was also unique experience for us. So in class, Judge Matata and I were discussing a while back because virtual moot court competitions are being held for law schools all over the country. We have virtual debates ongoing also. In classes, I also do that. We have debates and moots. It's not really difficult for experience. We just use the technology that we have. So for classes, we have Zoom meetings. We assign issues, and then it's nothing complicated. It's just simple. It's just like a courtroom scenario, and then for debates, depending on the topics that we have, we assign also debaters for discussion on the subject. As to our colleague here, Sir Noel mentioned, it struck the heart. We say that environmental advocacy should be our way of life, and that it should start with us in the family. We teach our young children, we teach people not to respect the environment, to protect the environment, and to conserve the environment. In the classrooms, I do not teach envi law in particular now, but I teach constitutional law. But in anything, in national territory, in envi laws, we always integrate the study of our envi laws as well as ethics, of course. So we say, Sir Noel, that even as judge in our earlier discussion, Judge, our good judge from Iloilo, mentioned about being good citizens, and that we should always advocate for that. In Iloilo, they say that before they solemnize marriages, the LCR require parties to plant and grow trees. I said that in our jurisdiction, in my court, and even I believe in Judge Cappadocia's court, we also require our parties, not just to plant trees and to grow trees before we solemnize their marriage. And even in our compromise agreements, our law officers, our PAO, and our prosecutor know our advocacies for the environment. So they include in the plea bargaining agreement the planting of the trees. So we say that environmental protection should be our way of life, in the family, in the classroom, in the work that we do in our community. So we thank this platform for us to have these conversations, for these continuing conversations wherein we learn from each other and we draw inspiration. So thank you to all who have inspired us. Attorney Jyoti, she had been lecturing about environmental law for so long already. I've been, a recipient of your lecture. And to everyone here, thank you for this learning platform. Good
Thank you,
afternoon.
Judge Jurley. Thank you very much. Yes, Amanda.
Judge Jurley, I might just add a comment, something that you mentioned when you were talking about the platforms and finding it relatively simple. And you're right, on one level, it is very simple. Where the hard work lies with using platforms like Zoom to run either an online moot or other types of advocacy or debates is really in the planning beforehand and making sure you have very clear protocols around even things like the etiquette around having screens on at different times, or how to establish speaking order. And, of course, over the last few years, some of that has become second nature, but we do need to remind ourselves of that, and that we have clear protocols in place. When we have our session in the morning tomorrow, we'll be speaking about some of those aspects around organising and ensuring engagement when we're in those online platforms. And you know, you're right, it's deceptively simple. But it is down to those very clear protocols in organisation and having clear expectations and boundaries around how the technology will be utilised to facilitate that synchronous engagement. But it's definitely possible to do. Sometimes we just forget we get lost in the technology and forget that's actually the groundwork that needs to be laid.
Thank you, Amanda. This is Professor Valones. Yes, before I go on.
Hello, ma'am. It's nice to have you here, no, ma'am, because I'm one of your dutiful students way back, and I learned a lot from you regarding the kind of environmental law things. So I also adapt and later have inculcated that learnings about environmental law in terms of the subjects I have taught in law school, particularly in the international law, because in the curriculum that I have taken with regards to the course syllabus on public international law, I have integrated these kind of environmental law concepts, particularly climate change, in terms of the separate section with regards to international environmental law. So undertaking that perspective, I have identified the hard law and the soft laws in terms of introducing that concept to those students, future lawyers in the Philippines, so that they will have the kind of enriching knowledge about the current setups of environmental law here in the domestic sphere and in the international sphere. So I have developed that kind of course syllabus in terms of the international as well as the important backgrounds of the domestic sphere. So applying from that perspective about international law, I have also engaged my students to be one of the participants in the recent United Nations Conference of the Parties, COP26, because I was the representative of the wider Asia in the United Nations for the Conference of the Parties. So by engaging my students in that kind of perspectives, they have been aware not only of the climate change principles, but also environmental law perspectives. And by engaging their practical knowledge, so by having such kind of video, so I have engaged them to be one of their voices to be heard before the United Nations. So by that kind of application, it's not only here in the Filipino students to be engaged in the whole global issues of climate change, but it also involves this kind of integrating curriculum in the law course. Aside from that, in the international law, I have also inculcated in terms of the course syllabus I have here in the human rights course. So not only in terms of those concepts and principles about human rights, but it also includes the second generation of human rights, which also includes the third generation about the collective and solidarity rights on the right in the environment and the right to self-determination. So by engaging that perspective to all separate subjects in terms of international law, in terms of human rights law, we have this kind of being a law professor that emboldens that kind of strategic thinking on how to have such kind of influence in terms of their directions as they go towards public interest subjects, environment, human rights, and in the different curriculums nowadays. So it is not only molding young lawyers to be competent lawyers in different fields in corporation, commercial law, but also integrating the climate change principles and the international environmental law perspectives as they practice law in their respective fields or areas. Thank you so much for this interactive webinar in terms
Thank
of
you,
the
Attorney Balones.
trainers training. Thank you
Glad
po.
to see you. Yes. Professor
Thank you.
Jonathan, you raise your hand. Couldn't sit here too.
Yes, and thanks for that, and thanks for a very stimulating conversation. Something I just wanted to add in. So 2 points. You know, and I think that what we're trying to do is to create autonomy. And, quite often what students always think about, the meaning of being a lawyer and the meaning of law is that it's just, applying laws and applying court case judgments from the courts. But, one of the ultimate goals of law school is to create autonomous individuals. And the reason I say this is that in Asia specifically, there is a trend of the law being an instrument of corporate interests, an instrument of illiberal forces, an instrument of authoritarian regimes. So that's the rule by law, right? So we want to have law students who graduate with the ability to understand and recognize that the law serves you, you don't serve the law, and that you have to have the ability to know when the law is wrong, and you have to have the ability to know when the government is doing something that's wrong. So you have to be able to question the law itself. But to do that, we have to orient the teaching in a way that encourages students to be autonomous, to think for themselves, and most importantly, to develop values. And so that was that entire comment I had earlier about values. And the reason why that has been adopted as sort of a mantra of rule of law aid programs by the United Nations, that they recognize that we have to have students develop a sense of values about what they think is right and wrong, so that they're able to generate autonomy, and that they can then speak truth to power, right, if necessary, that they can speak truth to illiberal forces and authoritarian forces, and protect the marginalized segments of our society and of our world. The second thing I'll add to that, and the way to implement this, so this is part of the reason why the pedagogy in a growing number of law schools in the US and Australia has been exercising something called, Amanda used the term reflective with a C.
We've lost sound, Jonathan.
Yeah, sorry. That there's a growing trend of law schools in the US and Australia of adopting something called reflexive teaching and reflexive learning. That's reflexive with an X as opposed to a C. And so the difference is that reflexive learning is a concept adapted from the humanities. And the idea there is that you're encouraging students to think about not just themselves, but to understand like how their beliefs and their values and their decisions impact their understanding of the world and impacts their relationships with society. So it's not just about themselves, but it's about themselves in relation to the world around us. And so that's that X. And one of the techniques or pedagogical techniques, since we're talking about it, is that as part of the assessments in any given semester, there's actually a reflexive journal. So students are actually keeping a journal where they're actually thinking and describing their understanding of what they're learning and how it impacts their understanding of their relationship with the rest of the world, right? It's very difficult to assess it in terms of like grades, like, 90, 100, that kind of thing. And so it's not the kind of thing that you make central. So it doesn't have the same stature as a final exam, for example, but it is a very useful tool to force students to really think about values and to think about themselves as autonomous individuals in relation to the law. And so it's because, the danger is students quite often will study for the exam. They'll study to get the grade. And the reflexive journal and the reflexive learning breaks them out of that and allows you space to encourage them to develop their own value systems. So I'll stop there. Thanks.
Thank you. Thanks, Jonathan. That's a great suggestion. And probably a helpful point to also remind everyone of the importance of completing your own reflective journal, but you could also be reflexive as well in your thinking about how your teaching practice might relate outwards as much as it is inwards. I'm getting the wrap up from Matthew. So I think we're out of time, although Commissioner has perhaps a comment to take us out on.
Thank you, Amanda. I wanted to comment further on the frustration of Professor Noel, but this was partly already mentioned by Jonathan. The heart of his statement, of his frustration, is about character. It's about integrity. But that is the biggest challenge that is being faced by law schools, not only here in the Philippines, but throughout the world. How can law schools produce lawyers who will not become, with all due respect, pigscars? That's the term we used to name prosecutors who are corrupt, who will not become hoodlums in robes, judges, no? The LAB and the Philippine Association of Law Schools is engaged in conversations on how we can attack this problem. In fact, in the United States, look at CNN, look at the problem of presidents and former presidents. The problem is brought about by the kind of lawyers surrounding them. So that's the challenge, no? That's the challenge for law schools, law deans. How can you produce lawyers who do not have feet of clay, who have integrity, who have character? In other words, who are not corrupt. In fact, early on in the 1980s, I was in active law practice. Up to the highest court of the land, oh boy, a lot of problem. I will not mention what the problem is, but Amanda, I will tell you what was that, no? I delivered envelopes to magistrates of the highest court of the land. So up to now, that problem is still there. I can understand the frustration of Noel. So, Pañero, we have problems with our prosecution. They easily dismiss cases on the basis of lack of evidence, conveniently, or lack of probable cause. It's difficult to question their decision, but the ultimate judgment is, it's this. Thank you.
And this is something that we were talking about yesterday, of course, this idea, which really sits outside environmental law. It cuts across the entire curriculum. And it's a movement, as Commissioner has just mentioned, that we've seen both in the United States and Australia and in other jurisdictions too, around starting to embed a culture of professionalism within the law degree from the beginning, and really instilling in students from day one that from this moment forward, they are a member of a profession. They're entering a professional discipline which has certain values and codes of ethics and morals that underpin it. And to the extent that we can give students every opportunity to flex that muscle and develop that through, as Jonathan mentions, reflexive practice throughout various points in the degree, encouraging them to question the role of law and whether it's fulfilling its obligations, then we're on the pathway, I think, to producing better lawyers.
So thank you, Amanda. That's a very good way of ending our session today. Matthew, are there any announcements? We start at 9 o'clock tomorrow.
Thank you very much. And we should thank our moderators and trainers for today. So tomorrow we do start at 9 o'clock, and we will have a bit of a opportunity to discuss some questions from day one. So a bit of reflective learning. And here, this book is available to win if you are able to provide Amanda with some good reflective practice. And there are 2 copies, is that right? And this is also for all our online visitors. So can I also say we will send out an email with the link to the model environmental law curriculum. And I'd ask you to look in particular at theme 3, the national environmental law, which we will look at tomorrow and try and do one session. So if you wish to pick your topic and bring along some resources, we will also send out a PowerPoint presentation, which we could fill out in the groups, and the same with our online participants. And so we will have some small sessions tomorrow to look at trying to develop a module that reflects some of these key issues. But again, thank you all very much for your presentations. Before we go, one of the things that I believe very strongly is recognizing champions. And I was privileged when I was chair of the Environmental Planning Law Group of the Law Council of Australia, which is Australia's peak body for the legal profession. We instituted an Australian Environmental Lawyer of the Year award and a Young Environmental Lawyer of the Year award to acknowledge the people that are actually doing the good work. I should just make an observation that I feel a little bit guilty saying that in a country like the Philippines, because most Australian environmental lawyers, we suffer paper cuts. That's our major problem that we face in defending the environment. And the true cost and the consequences in the Philippines is often significantly greater. And that is certainly something that I acknowledge, and which is why I feel privileged to be in a room with so many amazing environmental lawyers. But we have developed a series of videos, and one of which Angelo will play today to take us out on an optimistic note. You may recognize the subject matter of this Environmental Law Champions video. So thank you, Angelo.
In the Philippines, a longtime environmental champion, Professor Jerthy Mayo Anda has been working tirelessly for decades to defend the people and environment of Palawan. In 1990, Jerthy founded the Environmental Legal Assistance Center, now one of the Philippines' most active NGOs that helps communities uphold their constitutional rights to a healthy environment. ELAC and Jerthy work together with civil society groups to educate indigenous people and local communities to protect their sources of food, water, and livelihoods. ELAC's strategic grassroots approach was critical to their campaign to stop the planned division of Palawan into 3 smaller provinces, which could open doors for the easier passage of unsustainable, exploitative projects. Undaunted by political pressure and powerful interests, Jerthy worked with the Save Palawan movement along with church and civic leaders to mobilize students, lawyers, researchers, and community leaders to campaign for One Palawan. Together, they motivated tens of thousands of voters to keep Palawan as one. In 2021, record numbers of Palawan's people let their voices be heard and voted to keep Palawan unified as a single province. This is just one of the stories of the many environmental law champions across Asia who are fighting and winning battles for people and the environment. These champions are making positive changes that will echo for generations. Join us in this movement as we work to develop and support the environmental law champions of tomorrow.
Salamat po. Thank you very much. And thank you all our online participants for your excellent presentations and our in-person participants as well. And I look forward to seeing you tomorrow morning at 9 o'clock. Thank you.